Good morning. Welcome to Monday. And we have several bills this morning. And the first is HB 129 relative to the definition of the term evidence-based within public education. And prime sponsor, Representative Belcher, is here. And welcome back.
Thank you, Mr. Chairman. Thank you, members of the committee. I am happy to be here to introduce this bill as a verbatim copy of what was brought before this committee in the last session. This, apologies for the record, Representative Belcher, Carroll County District 4 out of Wakefield. And I should have pink cards already. So this bill got a somewhat favorable hearing the last time around. We came out of committee, no opinion going to the floor. And I do hope we can do a little better this time, but I'm happy to take all of your questions at the end. It is a fairly simple concept in this bill. Currently, federal law and rules define the term evidence-based, but they don't adequately define what the evidence in evidence-based actually is. This leads to problems in terms of ensuring that the evidence we're dealing with actually reflects the reality or the facts on the ground as to what is actually occurring. Under the current paradigm, objective evidence, such as a controlled study demonstrating increased proficiency and better test scores, is given the same weight as a mere survey asking administrators how they feel about the efficacy of a technique. The first set of data is objective and it represents good science. The second set of data is subjective and it represents not very good science at all. Presently, teaching methods often are legitimated utilizing the second methodology of bad science. They're often legitimized using surveys instead of objective data. When the data we're using to evaluate is subjective, bad science, it doesn't correspond to reality, or at least it doesn't necessarily correspond to reality. And when it doesn't, we wind up with things like kids who can't read or do math or socialize properly. This bill simply firms up that definition of evidence to require that the evidence we're using be good, objective, science-based evidence. I will note here that this only works with pedagogy. It doesn't cover subject materials. So this bill doesn't speak at all to what may be taught in a classroom. It only speaks to how we ought to be going about teaching things in a classroom. So it's about techniques and pedagogy, not subject material. Not only can we reasonably expect that this change in definition would bring positive effects in student learning and proficiency, we also stand to see significant cost savings if we were to implement this. Anyone with a background in education probably understands the frequency with which fads wind up getting chased in the field. People want to conform to the current thing, the current in thing, and the best of the best way to do things in the field. And this also legitimizes the publication of new texts on an ongoing, regular basis and the cost of retraining. By properly amending the definition, we can significantly curtail this fad chasing within the field of education. By doing so, we limit the degree to which publishing of new materials and retrainings becomes necessary in the field. As we gravitate more toward effective, efficient ways of doing business and teaching, we get away from fad chasing. Lastly, to the fiscal note, I don't doubt that there might be some small cost in implementing this, especially right off the bat. I don't think it's probably necessary to have an additional person involved because the department is already doing this. They're already applying the rules from the federal government on evidence-based education. This simply tweaks the definition to make it a little firmer. So it's already something that's done, and I don't think it would be too difficult to kick it up a higher gear and continue doing it with this new definition in place. And with that, I'm happy to take questions.
Questions from the committee? Representative Woodcock.
Thank you, Chairman Cordelli. Welcome, Representative Welch. Good to see you back again. Like on the physical note, I agree with you. It seems to me most of the physical notes that we receive from DOE, it must be an automatic placeholder. Let's throw in another staff person, another $150,000, no matter what the issue is. So I agree with you on that piece. However, moving to the main text of the bill, can you just explain to me a little more clarity what you mean that it's only pedagogy and not subject material?
Yes, thank you for that question. I'd be happy to delve into that. So it's a matter of when you're teaching, let's say we're teaching reading. It doesn't have anything to do with what reading materials can be brought in. It doesn't say this book over that book or this text over that text, nothing of that kind. It only affects the manner in which the book is being taught. So for instance, for those of you who may be familiar with the concept of cueing, well, it appears from my best understanding of the science that the cueing method of reading has been largely discredited by good science. But it remains, in many cases, a method that's utilized. And perhaps there's occasional methods or occasional times where it's useful. I'm not entirely sure. But there are newer methods utilizing more phonics-based approaches that are more classical, really, that have been demonstrated, according to my understanding of the science, to be more efficacious, more useful. So in both ways, you would potentially be looking at the same book, the same material. It's just about how it's being taught, cueing method versus phonics. So this would not affect the material, it only affects the methods. And in order to qualify, all that you have to be able to show is good science demonstrating that the method works. And that shouldn't be difficult at all because we have colleges of education all across this country constantly doing scientific studies, looking at different pedagogical methods, and legitimizing them via largely good science. I'm sure there's some bad stuff in there too, but largely good science. So it shouldn't be hard to find good methods that we can legitimate using science.
Thanks, Chairman. On a different topic, thank you, by the way, Mike, on that. Different topic. The fads in education, sort of like the fads in clothing. My father always said, don't throw your ties away because the skinny ones will be back. Okay. But that being said, the fads in education, what is the difference between a fad in education and improvement in instruction and things that have changed because we've done empirical research and we see that this may be, or we want to find out if we can do a better job by changing the way the box is built?
Thank you, and that's an excellent question. So what we're dealing with is two methods of sort of legitimating or saying this is the reason this is true and correct. On one hand, we have the sort of socially negotiated method. On the other hand, we have the science-based method. On the socially determined side of things is where we get the concept generally of fads that generally are adopted not because they're being proven to be efficacious, but they're being adopted because they're being adopted by other people. So everybody kind of jumps on the bandwagon and tends to do the same kind of thing. Now, that doesn't necessarily mean that all fads are bad, because you could have a fad toward something that's science-driven, in which case there's nothing wrong with that. But the concept of a fad generally is sort of scattershot. Maybe it hits, maybe it misses. But when we bring good science in, we don't have to miss.
Thank you. Thank you, Chair.
Yes, Representative Selig.
Thank you so much, and thank you for taking my question. I'm just processing your information, and I'm curious. I think back to when I was teaching kindergarten and how, I was in a situation where I was able to teach all of my students individually because we did team teaching so that I could teach reading, for example, or math based on how each individual student learned. And I'm trying to understand how that, which I guess you would say some of the methods I used were not evidence-based because they were what was developing then for students who didn't particularly do well with, for example, phonics-based instruction, but needed whole language instruction, which is a totally different reading strategy versus an Orton-Gilliam approach. And so I'm trying to figure out how that relates to this term and also what falsifiability means.
Thank you for the question. That is an excellent question. I was a bit remiss in actually not covering that in my introduction. So the scope of this bill is looking to affect things that are adopted at the level of the school boards and the state. It is not meant to jump into the individual teacher's classroom and tell them that they can or cannot do X, Y, or Z. It actually specifically exempts individual teachers in individual classrooms from the requirements of the bill. If they feel there's a necessity to do something, they can do it. And they don't have to justify it based on the requirements of this bill in terms of evidence-based. They can just do it. And I think that flexibility is necessary, and I think it's good. In terms of the falsifiability, it's a term within the scientific field of study that suggests that whatever the proposition is, you have to be able to do some sort of investigation, scientific analysis to determine whether or not it's false. You can't always prove something true, but you ought to be able to prove things are false. So just a simple 10,000-foot view, you should be able to undertake a scientific method-based approach to determine what reading method works the best for the largest group of individuals. Maybe not universally, but you could say, okay, which works best? And if a method is bad, you should be able to show scientifically that, okay, this doesn't really work. But things that aren't falsifiable would be like big claims that have to do with metaphysics and certain epistemological claims like dealing with religion and things of that nature. So it sets aside things that are not falsifiable in terms of things that are falsifiable. And things that are falsifiable are necessarily items that are subject to the scientific method.
Further questions? Yes, Representative Freeman.
Thank you, Mr. Chair, and thank you, Representative, for bringing this in front of us. For those of us who aren't educators, I appreciate the fact that you're breaking this down into more layman's language. My question to you is that would the state standardized testing qualify as a scientific study?
Thank you for the question. The testing in itself is not a scientific study because it's not designed as a study, but it could be a portion of a scientific study. So, and I expect it often is the portion of a scientific study where a college of education or some organization will undertake a study that looks at, okay, we're going to make this change. We're going to attempt to design this study to control for all of these other variables that impact it. And we're going to have our measurement based on test scores. And you can put those together. And if the study is well designed, you can reasonably correlate the change to the test scores. So yes, in that way.
Yes, Representative, welcome back. Or welcome to this committee anyway.
Thank you. Thank you for taking my question. If I understood you correctly when you were responding to Representative Selig's query, you're indicating that the bill applies to boards and state efforts, not to individual teachers. Can you direct me where in the bill we can understand that it doesn't apply to individual teachers? I'm not perceiving that.
Yes, give me just a moment to find the language. Yeah, so if you look at under Roman numeral 1, it identifies the scope to who this is applying, and it defines educator training policies, and any pedagogical methods attached to or accompanying curriculum adopted by the Department of Education, local school districts, and any other regulatory body that may prescribe teaching methods. So specifically left out of that was individual teachers within their classrooms.
Follow-up?
Thank you. So I appreciate you highlighting that. And I would be concerned that by not actually stating that it doesn't apply to individual educators, it could be interpreted to do so.
Thank you.
Representative Cornell.
So in fact, if a school district passed ways of how they want things taught, and a teacher decided, no, I'm not going to do that because this works better, isn't that teacher opening themselves up to being insubordinate or not following rules and being reprimanded?
Thank you. I would imagine so. This bill does not seek to at all touch the educator code of conduct or any sort of practices within the district regarding that. This simply says that under this bill, that would be allowable. School boards are certainly authorized on their own to decide if something steps outside of the scope of what they consider reasonable.
Thank you.
I had one question. You referred to Roman numeral 1, where it indicates that the content of the curriculum is not impacted by this requirement. But in Roman 4, it says that districts shall make scientific studies available, and if the curriculum provider is a third party, the department may require the curriculum provider, to furnish studies that they are evidence-based. So it sounds like you are in Roman 4 talking about curriculum requirements.
Thank you for the question. And this is that little bit of a area where there's a small overlap that occurs between pedagogy and curriculum. And that occurs because textbook providers, for instance, will often include not merely material, but they will include instruction guidance for how to go about teaching something. And if they're going to be including such instruction guidance, that is pedagogy as opposed to content. So it would fall under the scope of this bill. And rather than requiring that the local body go out and find the studies, this simply authorizes them to go to that textbook company and require them to furnish them with whatever studies they used to legitimize placing that within those texts.
And if the provider does not want to include, provide information to a little old governor when we're a school district, what is the result?
That's a very good question. From my understanding in textbooks, which is not huge, but there's some, they don't just tend to willy-nilly pick things and to throw in there that are not being associated with some formal method of pedagogy. And as long as there is that formal method of pedagogy, there's going to be scientific evidence and scientific studies for it that can be pointed to. If they choose not to, then the adopting department or SAU would certainly have the recourse of going elsewhere or coming to this body for any sort of additional requirements down the road to hold them accountable for it.
Yes, Representative Cornell.
To get back to the fiscal note, I agree that maybe it won't cost the DOE another person to do it, although I know that they have a lot to do, but it does say the department states this will increase local expenditures by an indeterminable amount in 2026 and each year thereafter. So isn't this just another bill downshifting costs to the local taxpayers, which is something that we really are trying not to do, because I know my property taxes went up a lot, and this will just increase my property taxes again if it has to be absorbed by the towns and the cities.
Thank you for the question. I would say no and no. No on two fronts. So first of all, the idea of, I'm not sure I necessarily agree with the idea of downshifting, because we're talking about money that's coming out of the pockets of taxpayers, whether it goes to the state first, then the locality, or directly to the locality. It's still the tax that's covering the cost of education. But to go a little more in depth on the why, what we're looking at here is the reason that they might not be able to determine immediate cost is because they can't be 100% certain how many methods that are currently in use might not be science-based, which frankly seems like a pretty good reason to spend a little bit of money if we need to update our methods to bring them in line with the latest science in order to make the best gains for the children.
Representative Damon.
Thank you again, Mr. Chair, and thank you for taking my question. I'm wondering how this would apply or affect the actual research process. So, for example, if UNH is doing pedagogy research, which I believe they do, and they need students to do that research with, probably those students are receiving education through the public school system that you're directing this at. So are they then curtailed from doing the research that you're promoting as the premise for this bill because the science of that particular pedagogy has not yet been established? That's the point of the research.
Thank you for the question. I would say first, no, it really is not looking to restrict the ability to conduct research in any way. However, to get specific to the point you're making, I would suggest that if there is any entity making a suggestion that we make a significant departure from accepted best practices and standards in our public school students in order to conduct a study on them, we ought to have some reason to believe that that's going to work that can be pointed to and say, this is some good evidence that suggests this ought to work. Otherwise, we're just kind of treating kids like lab rats, which is not an ethical thing, I would think.
Follow.
So where and how does that, I'll call it preliminary research, happen to establish enough evidence that then it would fit your standard for what could be researched with the students?
Thank you. So we're getting into some really important detail, but they're also sort of edge cases. What I would say first is that the totality of the body of evidence that's out there is so significant, it's so large, that you generally ought to be able to point to some studies that say if what you're trying to do is legitimate in any way, you really should be able to point to some studies to say, okay, this looks like a method we should be utilizing for this reason. And in such cases where you can point to such evidence, you should be able to proceed with the research. As far as trying to concoct really, different thinking kind of stuff, that is going to be something that I would argue shouldn't be just broadly inflicted upon public school students when we don't know what kind of outcomes we're going to expect. We have such a broad body of evidence to draw from at this point that we can look and find good methods within what exists and then take the next steps that take the current evidence and take steps beyond it without completely trying to reinvent the wheel and potentially do great harm to students.
Representative Selig.
Thank you, and sorry, it takes me a little while sometimes to process all the questions. I'm curious whether the state the State Department of Education has approved curriculum that you would consider not evidence-based, and how you would determine that from all of the various curriculum they've approved from K to 12.
Thank you. Are there currently things out there that do not fit this? Yes, that the state has approved that do not specifically fit this. I can't be 100% certain. I do know in my own research that there are broadly some fields within education that trend more toward subjective analysis than objective analysis in terms of legitimating certain techniques and different teaching methods. But as far as determining that down the road, I'm not going to be doing it. There's some oversight capacity clearly within this body to be able to watch over that whole thing. But that's something that is within the bill for us to write the law that the executive then executes. So it would be over on their side of the building that they conduct those sort of analyses.
Follow, yeah.
Thank you for taking my follow-up. Could you give me an example of something that you think would be a subjective thing that's been approved? Because I'm not clear on what you mean by that.
Sure. It's been my understanding that, especially when it comes to some of the reading methods that were popularized in the last maybe 20, 30 years ago, that there was an emphasis placed not on objective score metrics as far as can you read better, can we demonstrate that you read better, but were legitimized through surveys happening. In more recent times, I think there are portions of fields such as trauma-informed education, social emotional learning that trend, not entirely, but certainly in some cases, trend towards subjective methods of evaluation instead of the objective metrics.
Representative McDonald.
Thank you, Mr. Chair, and welcome back to Education Representative. Am I correct in saying that this would not prevent students from being asked to take surveys in school? It simply just prevents their surveys from being presented as evidence-based when it's self-reported data.
Correct. This doesn't have anything to do with a prohibition on surveys or anything of the kind.
Great, thanks.
See no further questions. Thank you very much, Representative. Anne Marie Banfield.
Hit the button. My name is Anne Marie Banfield. I am a parental rights advocate focused on excellence in education. Today, I come here in support of HB 129. Some of my background involves tutoring elementary and middle school children in mathematics. I also had the pleasure of participating in an online forum with mathematicians and math teachers from around the country. For those of you who remember the math wars about 15 years ago, this forum was set up to promote quality math curriculum and pedagogy in schools. The mathematicians who participated were some of the best and brightest working at our top universities. Needless to say, I just kind of watched and listened and asked questions. They reviewed math curriculum and pedagogy in detail and identified the numerous problems within some of the, back then it was textbooks. The problems they pointed out were exactly the problems I saw when I was teaching kids math. If you're going to expect kids to discover math, you better expect them to have to be able to access a tutor, because kids don't discover math. Today I'm on a forum with math teachers from around the country who gather to share ideas on teaching math. They talk about teaching methods that have had a positive impact on learning and share information about some of the faddish teaching methods that do not work well in the classroom. What I learned from teaching children myself is that children need a good quality math program and a good teacher. I do not subscribe to the idea that kids can discover math on their own. While there may be a few outliers, most kids need direct instruction or their parents will end up paying for a tutor. This idea that teachers should be guides on the side marginalizes the value of teachers in our classroom. Too many teachers are floundering and looking for quality information on teaching methods and quality math programs. I'm grateful that these teachers are collaborating to find math programs and teaching methods that will help them fill the gaps. I think HB 129 is attempting to identify good quality teaching methods so teachers are not having to search for this on their own. I'm also going to point to a position statement that I have here by the Aletheia Society. The Aletheia Society is committed to advocacy rooted in rigorous research and evidence. They believe the most effective advocacy is guided by data and insights that inform policy and practice in special education and the related fields. So this is a position statement in response to the NCTM, the National Council of Teachers of Mathematics. So in their position statement, they're replying to the NCTM. And they say, a position statement from two national organizations, the NCTM, Teachers of Mathematics, and the CEC, Council for Exceptional Children, focused on the teaching of mathematics to all students with disabilities is timely. Given the strong research base in special education about mathematics, the focus on CEC teacher preparation standards about the use of research-validated practices, and the focus in both general and special education legislation about the use of research-validated practices, the expectation is that such a position statement would rely on a consensus of current evidence in the field. Unfortunately, the NCTM and the CEC position statement falls well short of this expectation. The NCTM and the CEC position statement provided a list of actionable recommendations for the mathematics support of students with disabilities. However, many of these recommendations were merely beliefs and philosophy without significant and rigorous research to support them. We expected better from a position statement meant to inform the crucial and complex practice of providing mathematics education for all students with disabilities, and thus call for a position statement that is grounded in now considerable knowledge base of effective mathematics instructions for students with disabilities. In 2021, the What Works Clearinghouse produced a high-quality review in which some of the research on assisting students who experience difficulties with mathematics was considered. The WWC review resulted in 6 recommendations with strong levels of evidence. Yet only one of these recommendations, in other words, mathematical representations, was mentioned in the NCTM position statement. We would expect a position statement for students with disabilities to focus on all 6 recommendations, including representations, mathematics vocabulary, number line, computation fluency, word problem solving, and systemic explicit instruction. Among the many omissions from this position statement is an emphasis on systemic explicit instruction in the high leverage practice documentation from CEC, the practice with the strongest research base to support its use with students with disabilities. It's not much longer, but I'm going to stop here. If you go to the American Federation of Teachers website, you're going to find a study, and it's about it's called Putting Students on a Path to Learning, and it is a study that shows that guided instruction is the best method of teaching math in our schools. Representative Belcher brought up how some of these programs in our schools dictate pedagogy. He might not have used that word, but I will use it. They dictate pedagogy to the teachers. You open up a program and the program says use inquiry-based learning. Well, that's code for get yourself a tutor. And not all of these kids can afford tutors. Not all of these parents can go and hire tutors. So what happens is those kids fall through the cracks. When the teacher is not teaching, but is sometimes told, yes, sometimes they are told, you have to do it this way. And they're going to have to do it that way, unfortunately, if that's what they're being told. But I think the point of this is let's narrow down what is evidence-based, what is research-based, so that at least they're not floundering around trying to figure out because this is what they've been told works, and then they're seeing it in their own class that it's not working. So that's my statement. If you have any questions, I'm happy to provide them. I've just seen it personally. This idea of this project-based learning in math and inquiry-based learning, it marginalizes the teacher in the classroom. And I don't understand it because our teachers are professionals. They go to school to teach this, and then they're sidelined. And that doesn't help students, but it certainly helps tutors if that's what you want to do.
Thank you. Any questions? Yes, Representative Hall?
Mr. Chair, and thank you for taking my question. So is this, your idea about not doing inquiry-based learning and stuff, is that for special needs only that you're speaking about? Or are you
No,
speaking about all students?
absolutely not. All students. And again, you know, I like that there's an exception that the teacher can divert from that, if so be, because when you're talking about a gifted student, they have that capacity a lot of times. I didn't get the kids who were gifted in math. Matter of fact, my son's gifted in math. And guess what he would do? Because my kids were in a school back then that used this pedagogy. All of his friends would call him at night asking him to explain the math that the teacher refused to teach. Now, this woman was an amazing woman, this teacher. She was told, use this constructivism, use this pedagogy in the classroom. And so he'd come home. Some of the kids I was tutoring, some of the kids would call him and say, can you explain how this works? So a lot of times what happens is your gifted kids can work their way through a system like that. They can figure it out. So in a class like that where you say that you separate the kids, maybe that's something that those kids don't need as much as explicit instruction. But even still, my son, who is gifted in math, would still come home frustrated, angry at a teacher who is an amazing person, but she was told she had to do it this way. So the frustration and the anger is aimed towards the teacher. Parents are calling the teacher, why aren't you teaching my kids? Why aren't you teaching them math? And so this is manifests itself. So I'd get these kids, I'd actually teach them, and I learned what it means to be a teacher at that point. Because when that light bulb goes out and when that self-esteem improves because somebody's actually teaching them, it's like a foreign language. Do you just figure out a foreign language? So sometimes you pretty much have to be taught what the words mean. And so what I like about this, and yes, I see it in the programs. I analyze math programs all the time, and it's in there. It tells the teachers how to teach. It's in the grants. I don't know if you know this, but sometimes when we get grants in the schools, it's dictating pedagogy in those grants. That takes away the autonomy from the teacher. So yeah, I do want a teacher to be able to, maneuver at the same time.
Thank you.
If that makes sense.
Sure.
Thank you for taking my question.
Sure.
Could you clarify again for me? I got a little confused by the words access a tutor. I'm missing, I know what you're saying about a tutor, but I'm not completely understanding why a tutor would be doing the job that I know I always did, as far as using techniques that were evidence-based.
Accessing a tutor would mean that if a student is in that environment, in a classroom where they are using the discovery, constructivism, inquiry method, project-based learning, those kind of situations which is teaching methods, pedagogy, where they're not actually learning or they're not understanding because maybe they're working with groups of kids and they're not really understanding how to work through a math concept, then a lot of times, then that's how I would get students. So sometimes it's the curriculum, sometimes it's a teaching method, sometimes it's both. Help my child because this is what's going on in the classroom. And the anger's aimed towards the teachers, and I'm always like, don't necessarily blame the teacher, they didn't pick the curriculum, and a lot of times they're told this is what they have to do.
Thank you. Representative Damon?
Thank you. Very short question. What is the name of the society that you were quoting their position
I will-
statement in response
Sure.
to the National Council of Teachers of Mathematics?
The Aletheia Society, it's ALETHEIA, and I'm going to give you a copy of this so that you can look at it. And then at the same time, I would also go read this position statement. You know what, I'm going to email it to you because it's got links in it. Also, the position by the NCTM that they're criticizing.
Thank you. Representative Terry? I'm sorry. Hold 1 second. A follow-up? Sorry.
Thank you. Thank you for sending that. And would you also include the link to the position statement that they're
Yes,
responding to?
absolutely, absolutely.
Representative Terry?
Thank you. At one point in your testimony, in your narrative, I believe that you mentioned that there were 6 recommendations that were made by, was it the National Council of Math Teachers, to a higher governing body, 5 of which were either rejected or ignored, only 1 of which was adopted. Can you, do you have any idea, or do you know why the other 5 were not either responded to positively or rejected, and what they are, and how this bill would address the concerns of the NCMT that were ignored or rejected by the higher governing body?
I brought this as an example, mainly as an example of the difficulty within these societies, within the NCTM, within a society like this that represents the students with disabilities. How will it impact this particular, how will it impact the bill? I think it's just an example of why it's needed, why we need to narrow down the evidence base, why I think it's good for public schools to narrow it down, because at the same time, you've got these situations where, for instance, in Manchester, if this is what they're doing in a classroom, these kids may not have access to a tutor. So if you are, now somebody in Bedford, they might be able to afford a tutor. But the point is if we can narrow down what actually works well in pedagogy, and again, that AFT, what's on the AFT, American Federation of Teachers, I'll send that too. It is a study that shows that guided instruction works best in the classroom. And I feel like it's very, I just have a strong belief, just sitting with kids and looking at all of the documentation and evidence, that this attempt to remove a teacher from instruction, not completely, has really damaged. It's been going on. The NCTM has been highly criticized by the mathematicians I worked with 15 years ago. I can send you that information. Some of you may have already read it because I've sent it to the commissioner in the past. So I'm happy to send you that. But yes, the NCTM has been a major problem in math education. They came up with the fuzzy math standards back 20 years ago, and they were highly criticized by these mathematicians around the country. So we were, and I think that they had the evidence to prove it. If you look at the TIMSS test, we're 25th on international scores. This is what they would point to, the NCTM that has been involved with math education in this country. So you're asking me to say, why would they do something like that? Why would they do that? Now you're asking me to get into their head, and I don't think that I could provide you a honest answer. I could guess. I mean, to me, I would never trust them from years ago and I mean, these mathematicians were, well, I'll send you information on it.
Thank you. Follow up quickly, please.
So I just want to be clear. You are not aware of why the recommendations were rejected, leading to your frustration and the frustration of other educators who hold views similar to or the same as yours.
The why?
So would this bill be helpful to you in attempting to move in the direction of resolving that frustration and achieving the laudable objectives which you are stating for us today?
I believe it would. I believe that there's enough evidence out there to promote good quality pedagogy in the schools. I think there's enough evidence out there to promote good math programs in the school, but that's not what this bill is doing. So yes, I do believe that would be. I think the criticism a lot of times, NCTM, is all about hands-off teachers, let kids discover learning. And so what they're basically doing is saying you're not including information, good information, like maybe what the AFT has on their website, to counter what their position statement was, what they put out there. And this has been going on for decades with the NCTM.
Thank you very much. Seeing no further questions, thank you very much for your testimony. And that will end the hearing on HB 129, and I am going to turn the gavel over to Representative Dry for the next bill.
We're going to take a couple minutes to get straightened out and move around. Just Right, we're going to open the hearing for House Concurrent Resolution 6, and I'm going to introduce the prime sponsor, Mike Belcher, Representative Mike Belcher.
Thank you, Madam Chairwoman. Thank you, members of the committee. I will do my best this time around to not trigger an earthquake with my testimony, but I make no promises. Okay, I suspect everyone here is familiar, at least in a basic way, with the foundational facts that regarding the incident that precipitated this resolution. For those needing a refresher or more details, there are 2 media articles containing details that I have passed around. You can peruse that at your leisure. First, it is within the purview of this body as the grand inquest of the state to remove any office holder in either state or local government. After all, it is in this state, according to our Constitution and judicial precedent, localities have no authorities not granted to them by this legislative body. If we can create a position by statute, as we have here, we have oversight of that position. Second, this is a resolution calling for a removal for cause. That cause is several-fold. The actions taken represent politicization of the position and the adoption of a protected class of rules adopted not by this body, but by the locality and in contravention of this body. The parents in question that were impacted by the incident were charged with harassment by the superintendent in question in this position. And severely punishing actions were taken based off of that charge. I have included with the handouts a copy of New Hampshire RSA 644-4, Criminal Code defining harassment. I've been cut off. I won't read the whole law. Please do peruse it. You will find that the allegations made against the parents in question for the behavior in question meets none of the items outlined in New Hampshire RSA 644-4, harassment. Rather, the rules adopted by a locality meant to govern students on school time, minor children, were applied to adult citizens of this state in trying to speak freely in quiet protest of government action. It is not reasonable to apply such rules to an adult in New Hampshire, citizens who have the absolute right, within reasonable application of time, place, and manner restrictions, to protest their government and to speak freely. Under no circumstances can text on an article of clothing that is not obscene or vulgar be barred under time, place, and manner restrictions. Time, place, and manner restrictions are designed to prevent people from stopping proceedings or interfering unnecessarily in proceedings. Quiet protests can never be that. Further, the punishments inflicted, including a total prohibition of parents stepping foot on school grounds for any reason, is an outlandish punishment that ought to be reserved only for legitimate threats and ought to include due process of law for deprivation of a liberty interest on the part of that parent. The prohibition rendered so far exceeded both the authority of the position of superintendent and the punishments themselves so far exceeded any reasonable application in the circumstances that this cannot be viewed as anything other than politically motivated, a move meant to inflict a chilling of speech generally on New Hampshire citizens. There is substantial historical precedent for the use of such a resolution in this state, going back as early as the early 19th century. We have not just a power, but an affirmative duty to act where citizens are deprived of their rights by a person holding an office created by this body. Thank you. I would be happy to take questions.
Thank you. Yes, I'm going to recognize Representative Hall.
Thank you, Madam Chair, and thank you, Representative, for taking my question. I'm just curious, given that this is in the courts right now, given that it targets a specific individual, did you get any pushback at OLS or in the Speaker's office with this legislation, or?
Thank you for the question. There was, pushback isn't the right word. There was some understanding difficulties in crafting this bill under what section of law in the Constitution this was falling under, because this is not merely a concurrent resolution. That is the manner in which it is drafted, but constitutionally this falls under a bill of address.
Representative Selig.
Thank you very much, and thank you for taking my question. I'm trying to understand where your motivation comes from, given that you don't live in this district, you don't, as far as I understand, have children in this school district, you're not part of this district, you're from a community 45 miles away, and what would make this relevant to you, given that it's not something, wouldn't it be an issue for local control and for the local community to take their own personal stance about their support of their superintendent?
Thank you for the question. Absolutely not. We cannot sit by as representatives at the state level of government while the rights of citizens anywhere in this state are trampled by local government. It is within our purview to oversee local government. And as I said, as a Dillon's Rule state, local government only has the authority granted them by this body. Otherwise, they have no authority and do not even exist.
Representative Nato.
Thank you, Madam Chair. Thank you for taking my question. So reading all of this, and I've heard a little bit more about it, but this parent is obviously concerned for his daughter's better welfare, as case in point of the Olympics and the boxing competition. I kind of agree with that. They're not saying you can't play sports, it's just that there is a point in time where the physical ability is quite different as far as strength and ability. And one of the
Point of order.
I don't think that's what this bill is about, and I think it's point of order that it's a different discussion for a different bill. I don't think that's what we're here to talk about.
Could you phrase a question that directly addresses the topic?
Okay, so do you think his freedom of speech would be relevant here?
Thank you for the question. Yes, I do. I think a host of freedoms covered under the First Amendment to the federal Constitution as well as the New Hampshire Constitution are implicated here, including freedoms of speech and association and of the right to petition one's government. Yes.
Thank you.
Representative Woodcock.
Thank you, Madam Chair. Representative Hall, good to see you again, twice in one day. I want to move away from the issue, the topical issue that caused this concern, but more to the hiring, firing practice of a local school committee. I would think that having been in education in schools for way beyond 3 decades, that those authorities lie with the local school board to hire or fire a superintendent or assistant superintendent or business manager, then of course the recommendation of the superintendent on the way down. So I don't understand, honestly, why we would, I understand your concern about people's rights in your position. I understand, I'm not saying it's not legal. I'm suggesting that the school board has an authority to make a determination if they want to hire a person, fire a person under the collective bargaining agreement. And if it's an individual contract, the superintendent, that's their sole right to do that. So I don't know why we would want to oversee or override the provisions of the local school board dealing with the local, in this case, superintendent. Forgetting the issue specifically, but rather the idea. Thank you.
Thank you for the question. I think it's a perfectly fair argument to suggest that one would rather see such a decision left to the local school board. However, from a process standpoint, we have the authority to look at this issue because any person anywhere in this state who believes their rights are being deprived by a local body has the right to appeal to a higher body of government for redress. That's what's happened here. We're looking to a higher body at the state level to redress what wasn't handled at the local level. And there is great historical precedent for this. In the 19th century, mid-19th century, a county coroner was removed from office under this process.
Follow up.
1800 coroner, as we talk about this. I understand the piece, but I guess following up the same piece, we're not trying to redress the decision by the superintendent, nor the right of the parents to do what they think is right. I have no issue with that. What I have the issue with is that we're trying to tell the local school board how to deal with their superintendent. That's not our issue. Do we have the legal right? Absolutely. Should we be putting our feet in that water? Absolutely not. My opinion.
Thank you. I don't think there was a question. I appreciate the opinion.
Representative Damon.
Thank you, Madam Chair. Thank you for taking my question. Would you comment on what kind of precedent, if this resolution were to pass, this sets, and including in your response relative to, as you cited, Dillon's rule? I'm very concerned that this sets a precedent that state government could be involved in the hiring and firing of any locally hired person for any position whatsoever if there's a grievance.
Thank you. I am very hopeful to set exactly such a precedent that we might step in to directly remove holders of office from any position in this state where they have deprived citizens of their liberties.
Follow up.
Do you also incorporate in your now stated objection to remove holders of office all kinds of employees? I appreciate that information, but that's not what I was asking. I was asking about hired individuals, not elected individuals.
Thank you. And to make that distinction clear, under the government, there's only two types of persons. There's elected and there's appointed to office. All office holders, including employees, are office holders on the appointed side of government.
Follow up?
Go ahead.
I don't think I got the answer to the question. Thank you for the clarification on the terminology. But I'm trying to understand what you expect as precedent for every employee, however you define them, of a school district, of a municipality. So if I don't like the care of the roads in my town, and to be clear, I think my town roads are very well cared for, then can I petition to have the state remove my road agent?
Absolutely. People can petition for anything. And by right of our Constitution, we have the authority to do that, but it would have to meet the necessary threshold in both this body and in the Senate to make that happen.
Representative Freeman.
Thank you, Madam Chair, and thank you, Representative, for coming in front of us. I think it's very important that people understand that we all have rights. Can you cite, reference, or in your research, have you found any other instances of the state getting involved in school board matters at this level?
Thank you for your question. I'm not aware of any direct involvement in removal of a school hired personnel in the school board, but the school board exists under the same rubric of government as a county government or a local government does. It's under the state. So there would be no legal or constitutional issue as far as pursuing somebody within any aspect of state or local government under a bill of address by the New Hampshire Constitution, as has been done repeatedly in this state.
Thank you.
Further questions? Thank you very much.
Thank you.
I'm going to call Jerry Frew. Yes, since the sponsor's had all the time that he needs to explain this, we have a long list of people lined up. Could you please hold your testimony to 2 to 3 minutes?
Madam Chair, I'd be happy to.
Thank you.
Good morning. Madam Chair, members of the committee. My name is Jerry Frew, the Associate Executive Director of the New Hampshire School Administrators Association. I come before you to this hearing to ask that you deem HCR 6 as inexpedient to legislate, and here's why. It's not this body's responsibility to adjudicate free speech. That belongs in another branch of government. The hiring and firing of a local school superintendent is the responsibility of the local school board, not the legislature. This body doesn't necessarily know the facts or that are surrounding that incident being debated, nor is it necessarily familiar with the local school board's policy, whose enforcement responsibility is the superintendent's. Judgments and decisions needed to be made at that time based on the school district policy and ultimately with the obligation to provide a safe environment for students and others gathered at a school event. At the end of the day, this resolution exceeds the responsibility of this body, erodes the duties and responsibilities of a local school district, and makes assumptions based on a lack of knowledge of the facts of the matter. We ask that the wisdom of this committee prevail and determine this bill as inexpedient to legislate. Thank you.
Questions? Representative Selig.
Thank you. Representative Belcher made the statement that he thought the state should have the authority to override a school district or other local government elected bodies' hiring and firing decisions. Do you agree that that's an appropriate action?
Thank you for the question, Representative Sully. I claim not to be a constitutional specialist and would not be comfortable offering an opinion on that.
Representative Morse.
Thank you, Madam Chair. So if the local school board does not act on an unconstitutional action of a superintendent, if not us, then who is there to protect the parents and students?
Thank you for the question, Representative Morse. I believe that a local school district, local school board does have the authority and will make the appropriate decisions based on their knowledge of the matter and the situation at hand. I do believe that items of free speech are adjudicated in another branch of this government and in fact may well be the case.
Further questions? Seeing none, thank you very much.
Thank you, Madam Chair.
I'd like to call Clement Madden.
Thank you for having me, Madam Chair, and greetings to the members of the committee. And I appreciate the opportunity to speak on HCR 6, calling for the removal of the Superintendent of School Administrative Unit 67.
Could you introduce yourself, please?
My name is Clement Madden, and I am the Dunbarton School Board Chair and a member of the SAU 67 Board as well. Dunbarton is one of the two districts in SAU 67, the other being Bow, of course. I'm here today to express my confusion regarding why anyone in the New Hampshire State Legislature thinks that they have any right to terminate a lawfully executed contract between the elected officials that comprise the SAU 67 Board and their administrative leaders, including our Superintendent, Marcy Kelly. RSA 194C:5 Roman 3 states, in pertinent part, that, quote, the school administrative unit board shall have the authority to remove superintendents and other administrators, end quote. This law does not state that the board's authority is subject to the legislature under any circumstances. Simply put, the legislature has no authority here. I think this bill attempts to engage in an issue that is currently before a judge in federal court, specifically in a manner that has no meaningful impact on the process and appears to only be meant to grab headlines or otherwise try to whip up some sort of political rhetoric for their own benefit. More so, the wording of the bill appears to lack any understanding of the issues and nuances surrounding the multiple incidents that occurred on the sidelines of the Bow High School varsity girls soccer team games this past fall. We do not need to get into those, as this is not the court where that issue is being decided, which leads me to wonder why anyone, let alone a representative from Wakefield, thinks that they can inject themselves into a matter where they have no jurisdiction in a town where they don't live and do so in a manner that tries to preempt a federal court's ruling that hasn't been made yet. I think this bill is ridiculous, and I urge the committee to decline to move it forward. I would also add that Superintendent Kelly has the full support of the Dumbarton School Board. There is much more to the job of superintendent than having to deal with grandstanding individuals who appear to be attempting to get likes or otherwise trying to motivate a specific group of people by targeting a 14-year-old student. Our superintendent does a great job in all areas of her portfolio of responsibilities, and in the specific issue this resolution is attempting to highlight, she was dealing with a singular, unprecedented, and novel protest apparently designed to create headlines. During that process, she was working with counsel in a manner meant to abide by all the laws, regulations, and policies that are in effect from the federal government, the state of New Hampshire, the New Hampshire Interscholastic Athletic Association, SAU 67, and the Bow School District. Superintendent Kelly should be commended for her actions and not subject to some clickbait resolution like this.
Okay, thank you. Questions? Representative McDonald.
Thank you, Madam Chair, and thank you for your testimony. I imagine the superintendent, Marcy Kelly, is aware of this resolution. Has the Dunbarton School Board spoken to her at all about this? Is she aware of this?
Yeah, she's here right now.
Okay, thank you.
Representative Woodcock.
Thank you, Madam Chair. Just a good morning, Superintendent. Thank you for coming down.
Good morning.
Just a point of clarification. In respect to Representative Belka's putting this bill before us, as ACR. Now, it's not often at all that I agree with Representative Belka. Really. But I do think he has the right to do that. And I would say in my last 2 years of working with him here, he consistently brings bills that question the Constitution, how they're interpreted. So I'm not suggesting this bill is good. I want to be clear that I don't think his motivation was for his own personal gain. That's all.
May I respond to that or not?
He asked you the question.
I would suggest that since this is in a federal court right now, being decided as a civil issue, there really is no point to him trying to presume a ruling that hasn't been made yet, which is what his bill does. Nothing has been decided as unconstitutional.
I would agree with that, but that wasn't my attempt, but thank you.
Representative Selleck.
Thank you so much, and thank you so much for taking my question. I want to ask you the same question I asked the representative from the School Boards Association. Do you believe that the state legislature has the right to overturn the decision of an elected body within another section of the state?
In my opinion, and from what the RSA that I read said, no, they do not.
May I ask a quick follow-up?
Yes, follow-up.
Thank you so much. And if the voters in that district were unsatisfied with the decision, do they have recourse?
Yes, they do have recourse. Of course, there's always elections for school board officials. And also, if they are unhappy with a school board decision, they can go to the State Board of Education, which is how this works.
Thank you.
Any other questions? Representative Damon.
This isn't actually a question. I just want to thank you and all of the other school board members for your active engagement with public schools in these challenging times.
Thank you. I appreciate that.
Any other questions? Thank you very much for coming.
Thank you.
I'd like to call Bryce Larrabee.
My ears are burning a little bit since I'm Bow School Board, Bryce Larrabee. I've been the longtime chair of the school district and it's had a big impact on our district and obviously Mrs. Kelly as well. I'm here to speak on behalf of the entire board. Even though I'm the only one speaking on their behalf, we all are in agreement and we strenuously object to this bill. We support Ms. Kelly in all of her actions. And let me explain a little bit about that. The school board has really two fundamental jobs. It's creating budgeting and finance and creating policies. The administration is the ones that administer those policies. It's our policies that they administer, and it's at our direction that they do what they do. And we are still consistently happy and pleased with what Ms. Kelly has done and she does. our most fundamental policy, it's the protection of kids. It's the safety of kids. And it doesn't matter what the issue is. Our view is we're there to protect those children. Now, September 17th is the date when this incident happened. The school knew a week beforehand that there were people with plans to do something, disrupt that event in some way, shape, or form, targeted at an individual. The school looked into this. Those individuals even reached out to the school, both meetings and emails. The school knew something was going to happen. And Ms. Kelly took the action appropriately. She perceived something was going to happen that was going to make a child uncomfortable. And we put an end to that. We don't know what could have happened more if the school hadn't stepped in. Maybe there were even greater plans. We don't know. But this was a highly unusual event. I've coached over 1,000 games myself. My estimate is I've been to 4,000 on top of that. My son recently tried out for the Chicago Bears. Like, I know sports. And in those 5,000 games, I've never once seen a protest. And more importantly, I've never seen parents want to take the spotlight away from their child who's participating. So this is an unprecedented situation that Ms. Kelly was presented with, and she acted accordingly, and it had nothing to do with transgender rights. If parents were there to make fun of somebody because of their last name or their hair color or their shoes, we expect the school to do the same thing. We expect them to step in and not allow any sort of harassment to children. And even if that harassment doesn't happen, if they're perceiving that something like that's going to happen, we expect them to step in and do that. And we applaud what Ms. Kelly and the administration did. And
3 minutes.
If we're wrong on what we approach that, we don't want to be right. We are there fundamentally about protecting the children.
Thank you. Questions? Representative Hall.
Thank you, Madam Chair, and thank you for taking my question. Are you aware of the support that the Bow has received on the online testimony? I don't know if you've seen any of the testimony on how positive it is. You know, hundreds of people have, 90% have said that they oppose this resolution.
Actually, I am not.
Okay. Well, it's there
Thank
to
you.
read. It's very interesting. Thank you.
Any other questions? Seeing none, thank you very much.
Thank you.
I'd like to call Marcy Kelly.
Good morning, Madam Chair and members of this committee. Thank you for the opportunity to provide testimony this morning. My name's Marcy Kelly. I'm a resident of Samerton, New Hampshire, as well as a proud product of New Hampshire Public Schools. Professionally, I serve as superintendent of schools for SAU 67, serving the communities of Bow and Dunbarton. It won't surprise you to know that I'm here today to voice my strong opposition to House Concurrent Resolution 6, introduced by Representative Belcher, which calls for my removal as superintendent. This resolution represents a significant overreach by the state legislature and poses a serious threat to the foundational principle of local control that has long defined New Hampshire's governance and education systems. New Hampshire has a rich tradition of empowering local communities to manage their schools. HCR 6 undermines this tradition by allowing political interference to replace the thoughtful, localized decision-making that best serves our students and communities. Leadership decisions within our schools must remain the responsibility of locally elected school boards who are directly accountable to their constituents, not dictated by political pressures at the state level. As superintendent, my primary responsibility is to create a safe, respectful, and supportive environment for every student and staff member. Schools should be places where learning and personal growth are prioritized, free from political agendas or sensationalized media narratives. My role requires careful and sometimes difficult decision-making that is grounded in fairness, professionalism, and the best interests of the entire school community, while adhering to the law. Public education must remain a safe, stable, and apolitical space where students are given the tools to learn and grow. HCR 6, by seeking to remove me for political reasons, sets a dangerous precedent that jeopardizes school leadership and exposes it to the shifting whims of politics rather than focusing on the needs of students and staff. I urge you to reject HCR 6 and to reaffirm New Hampshire's commitment to local control. By doing so, you'll help preserve the trust and autonomy that empower communities to make decisions in the best interest of their schools and students. Thank you for your time and thoughtful consideration. I remain dedicated to supporting our schools, our staff, and most importantly, our students.
Thank you. Any questions? Representative Woodcock.
Thank you, Chairman. Superintendent, thank you for coming in, and I appreciate your comments. I don't have a question. I just want to thank you for being a superintendent of schools and feel badly for the difficulty you have had to go through in protecting kids. Thank you.
Thank you, Representative Woodcock.
Any other questions? Seeing none, thank you for your time. Thank you. Calling Dean Cascadden.
Misinformed. I think we're going to go after me. I'm the former superintendent of SAU 67. Larson's doing a heck of a job.
Not 5 minutes, 2 to 3. Yeah. Mike.
Man, Dean Cascadden, ex-superintendent of schools for SAU 67, now happily retired. Marcy made the absolute right decision. She did not violate these people's constitutional rights. The controlling Supreme Court case is the Tinker case, which every administrator learns. It has to do with wearing black armbands during the Vietnam War. There were students who wore them. They were suspended from school for expressing their political view. Students have a right to express their political views in school, and that right should not be curtailed. These were not students expressing their political view. These were parents who were guests at a high school sports game. That is a limited public forum. It is not a street corner where your First Amendment constitutional rights of free speech are unregulated. Superintendent has the right to regulate time, space, and manner. And if they are going to restrict speech, it has to do on the element of disruption. If a child brings a Confederate flag onto the school grounds, they may be suspended from school, they may not, depending on the case for disruption. You bring that into a black high school, suspend from school because you're going to call it disruption. You bring it into a white high school like Bo was, we'll probably have a conversation with you about the relative to disruption. Everything I saw about this incident, it was designed to be disruptive. Marcy was not only in her rights to suspend those students from school, it was her responsibility to. Now let's talk about NHIAA. NHIAA controls sports in the state. We have been looking into this transgender issue for over a decade. It is complex. It's not simple. Yeah, Connecticut, the state holders in the 100-yard dash are transgender females. Unfair advantage. 120-pound sophomore playing on a soccer team. You tell me what the issue is there, except you just don't like the fact that she's transgender. You tell me. All this other stuff goes away. Marcy was protecting a student who needed to be protected. One of the things about NHIAA is you do not single a player out on the other team. Shooting a foul shot, you shouldn't be talking about that person's mother, saying their name or anything. It's part of sportsmanship. These people were in the stands. They are guests of the school district. Yes, they're parents, but they don't have an unlimited right to come in and do whatever they want. It's a limited public forum, and the courts have traditionally recognized that superintendents and school administrators need that to go forward. And the last thing I'll say, actually two last things. One, this body passed a bill that said we're going to prevent bullying in schools. That's what Marcy was doing. There was a power differential of adults organized against a single student on another team. That's bullying. And she stood up and said, no, we're not going to let that happen. This body passed a law and asked us to do this. And final, does this body own superintendents? You used to. The Commissioner of Education used to sign our contracts. Now it's all local control.
3 minutes.
3 minutes? I get 3 left? Oh man, I'm on a roll. All right, you want control? Pay for it. You pay like a paltry $5,000 per student. The rest of it comes up here. No, it goes to control. It goes to who has the right to hire and fire.
Time.
5 minutes?
No.
I'm done.
You're done.
Thank you very much. Good to see you.
You too.
Meryl, good to see you. The rest of you I may not know.
Okay, Representative Selig and then Representative Freeman.
Thank you so much, and thank you for taking my question and also for having served as a superintendent and working with NHIAA, which I'm very familiar as a parent of an athlete. I'm curious what you were speaking at the end about who has ultimate control over the superintendent. So if I'm unhappy with my school superintendent, could you tell me from your perspective what's my recourse about how to address that?
You go and talk to your school board, and I have had, with a couple gentlemen that already spoke here today, some uncomfortable conversations with them about my behavior and what I did and what I was representing. And if you don't like that, you go and you vote your school board out, you get a new school board in there and get you. But it's a contract between the local school board with mostly local funds paying for it and the person who works for them. That's what it is. I mean, I don't see where the state as a legislature has the right to go in and mess with that, especially when you don't fund that much.
Representative Freeman.
Madam Chair, I defer. I have my question answered. Thank you.
Any other questions? Thank you for your time.
Thank you so much. It's always fun coming down here.
I'm going to call Adam Osborne.
I think this was left on. I'm Adam Osborne. I'm a principal in Bow. I'm an administrator in Bow. And I promise to be brief. I'll try not to go back over ground that others have covered. But I do want to touch on 2 points today. The first, I was going to talk a little bit more at length around the different levels of governance, local, county, state, and then federal. Because I think that's fundamentally why this is a dangerous situation. I think that I recognize that people from out of the Bow and Dunbarton locality may be displeased with the way things played out. The people within Bow and Dunbarton are pleased. And I think that's because it speaks to Marcy's character, but that's my second point. I'll come back to that in a moment. I think the danger is, and I'd like to offer an illustration to better kind of encapsulate this, would be, what if it were the federal government looking down on employees of the state? What if it were the federal government questioning who we had as a department head or a commissioner of, and you can fill in the blank for which agency, state agency you want. I think we'd be irate. I think the members around this table would be irate because it wouldn't be within the scope of their authority. It wouldn't be within the lane that we generally ascribe to that level of governance. And they should stay out of that. But by the same token, I think the state should stay out of this. This is an issue of local control. And that's a bedrock principle of public schooling in New Hampshire. We value that, and it's important. The second point I want to come to is really the question of, and I think I'm uniquely positioned kind of to talk to this because Marcy's my boss. I love working for Marcy. But the reason we're here today is part of the reason I love working for Marcy. Mrs. Kelly is a person of conviction and character. And the whole reason we're talking here today is because she believes she was doing the right thing standing up for kids. As an educational administrator, as a person who's worked in schools for 30 years, that's a core value. And if we're ever going to err or not err, let it be on the side of defending kids, as Mr. Larrabee said. If it's wrong, then we don't want to be right. And I agree with him. So I'll stop my comments there, but I think it's an issue of local control, staying within our respective governance lanes. And then I appreciate and applaud Mrs. Kelly for her conviction and character and strength of character standing up for children.
Thank you. Any questions? Representative Damon.
Thank you, Madam Chair. Thank you for taking my question. It's really a question for most who have spoken. Would you comment about the value to students of the way this process was handled and the respect for their safety?
I think that's a really good question with a complex set of answers. And just to be clear, I am the middle school principal, not the high school principal. So I was not front line to the varsity girls soccer game where this occurred. So all I can do is kind of imagine just as you would. But I think I have amazing respect for kids, period. Students are brilliant, smart, capable young people. And I think what they witnessed that day was a thoughtful response by Matt Fisk, the high school principal, Mike Desolitz, the high school athletic director, and also Mrs. Kelly, the superintendent, as they tried to construct a safe and positive environment for those two soccer teams to come together and play. They tried to be clear with what the expectations were prior to that game. Beyond that, I don't think I'm really too qualified to speak to the answer, just because I wasn't there and it's not my school building. But they were thoughtful.
Other questions? Representative Terry.
Thank you, sir. I've been hearing folks who've been testifying speaking about the primacy, the role and the primacy of local control. And I would like to just refer to or build off of a comment made by Representative Woodcock with respect to our knowledge of Representative Belcher and the particular concerns that he has for the protection of constitutional rights. And as I'm reading the resolution, it appears to me that Representative Belcher is effectively disagreeing with the local school board with respect to certain constitutionally protected rights. Sir, would it be your view then that if individuals were dissatisfied with the way in which the local school board adjudicated this situation, that the appropriate recourse, would they have any recourse beyond the local school board? And if so, and if it might be the federal judiciary or the state judiciary, the judicial branch, would it be the judiciary and not the general court in your view?
I'm not a lawyer or a legal expert, but I think Mr. Madden did a really good job of kind of addressing that when he talked about it being in a court process already. And I think it would be premature for this body to assume to supersede and step in over what the school board has done so far, because I think if I understand your question correctly, there's a legal pending case already in process.
Oh. So just to be 100% crystal clear here, that if folks at the local level are dissatisfied with the way in which this would be that this has been handled, that their appropriate recourse would be the judiciary, where I understand this matter currently lies.
I think two things, and I hope I'm not misunderstanding your question. I think if you're asking about local citizens of Bowen-Dumbarton, they would go through the Bowen-Dumbarton school boards. I think someone had referenced the state's Board of Education. Beyond that, I think I was probably misunderstanding your question initially.
Okay, thank you.
Any other questions? Seeing none, thank you very much. I'd like to call Jacqueline Coe.
Okay. Good morning. Thank you to the committee. I'm Jacqueline Coe, and in full transparency, I am a colleague of Marcy's superintendent in a neighboring town. But I come here today as a resident of Bow, urging you to find the resolution inexpedient to legislate. As a Bow resident, I vote for a school board, and their jobs are to set policy, establish a budget, and hire and fire the superintendent. So echoing what has been said in the testimonies today, I find this a gross attempt to usurp local control, and I am in full support of Superintendent Kelly and the school board and their actions to protect children. Thank you.
Any questions? Seeing none, thank you very much. Robert, last name starts with an M, and I can't read your handwriting.
Malay.
Thank you very much.
Thank you, Madam Chair. Thank you, members of the committee, for allowing me to speak on this proposed resolution, which I encourage you to kill that proposed resolution as quickly as it was offered to you.
I'm sorry, could you just introduce yourself, please?
Sure. My name is Robert Malay. I am a resident of Keene, New Hampshire. born and raised in Bow, New Hampshire, spent a lot of time there before they even had a high school, before they even had an elementary school, went to Concord High School where Krista McAuliffe was one of our teachers, and I was there at the time of that unfortunate tragedy as well. I am the superintendent out in Keene. I am coming as a colleague of Marcy's to encourage you to kill this bill or this proposed resolution for all of the reasons that you've heard. I'm not going to reiterate anything that has already been said, but I also sit as a member of the NHIAA Council, appointed by the NHSAA to that body. And Dr. Cascadden had already shared with you that we've been looking at this issue for a decade, and he's not wrong. And what Marcy did was what all superintendents, what all administrators and throughout all of our schools is charged to do, and that's to protect children, whether they are students in our district or they are visiting for a sporting event. We're talking about a 14-year-old kid who was there to play a soccer game. As a superintendent out in Keene, there have been numerous times where we have gone to our student body who had prepared signage of some sort to gain some sort of a psychological advantage over visiting team members, and we have taken them and we have escorted students away from that contest because it's just not okay. It's just not okay to do that to young people who are there to perform, to participate in a sport that they enjoy and should be free of any type of retaliation, whether it be from students or from adults. And so with your hard work that's in front of you, I hope that you would consider killing this proposed resolution as quickly as it came to you. And I'm happy to answer any questions you might have.
Any questions? Seeing none, thank you very much. Judith, good something. Okay, thank you very much.
My name is Judith Goodnow. I'm a resident of Bow for over 20 years. I'm not going to repeat everything that people said. I signed up early because I didn't see the crowd until a few minutes before you opened the hearing. But the only thing that I would add, in addition to the contractual interference and support that we have for Marcy, is that this doesn't have a fiscal note. And it would require the school board to spend money to find a new superintendent should that happen. So that just as a practical note. But as a resident of Bow, I can tell you that we fully support Marcy. Thank you.
Thank you. Any questions? Seeing none, thank you very much. And final, Michael Bissett.
Hello, my name is Michael Bissett. I'm here as a resident of the town of Bow, not as my professional capacity, although I do, for full disclosure, work as an assistant superintendent in a neighboring school district. I won't echo anything else that other people have said about the wonderful qualities that Marcy brings forward to the superintendency. She is a wonderful superintendent by all accounts. I do want to remind, however, the committee about the importance of following constitutional law. So if we're going to have a discussion today about free speech rights and about the rights of our parents to come onto our school campuses, what I would ask us to do is also remember that it's important to think about due process clauses within the Constitution under the 5th and the 14th Amendment. Right now, as we're sitting back, the 5th Amendment guarantees that no person shall be deprived of their life, liberty, or property without the due process of law. Currently, Superintendent Kelly is in a court case that's unsettled. It's a federal court case, it's undetermined, and yet Representative who's moved this forward seems to feel it's appropriate to publicly shame and humiliate Marcy Kelly's body of work and the decisions that she's made when she has not been proven guilty in a court of law in any way, shape, or form. Secondly, the 14th Amendment extends the guarantee to the states. The clause ensures individuals are treated fairly by the justice system, not by the legislative body, by the justice system. And lastly, the 6th Amendment guarantees the right to a fair trial, including the right to confront witnesses, the right to a public trial, the right to impartial juries. This framework supports the idea the burden of proof lies with the prosecution, not public sentiment. So I ask you to think very carefully about your balancing of your equation when you want to look at one clause under the Constitution, but willfully ignore many, many others. Thank you.
Question, Representative McDonald.
Thank you, Madam Chair, and thank you for being here. You appear to know quite a bit about constitutional law, so my question is kind of along those lines. If this HCR were to pass, since it is a resolution as opposed to a bill, is there some teeth to this? Is the school board forced to comply with this?
So I'm going to answer your question. I am no more an expert than you are because I graduated from a high school, a public school that taught civics, and I'm actually wonderfully glad for that experience to have that opportunity to know a little bit about what constitutional law is all about. That's the limitation. However, I would turn that over to lawyers who know better than I. But I will say this, that as a resident of Bow, as a town of Bow, when, not if, I suspect that the board was tasked by the state to move on this particular action, if that was to be the case, I would be happy to see a small increase in my taxes, which are already very high, for the funding of the lawsuit against the state for the overreach on their ability to try to do what it is that they think that they're able to do.
All right, thank you.
Representative Selig.
Thank you so much, and thank you for taking my question. I'm curious if the state were to pass this legislation, or this resolution, sorry, to make sure I'm being precise with my language. What do you think? Do you think it would have a chilling effect on the ability of school boards to be able to hire and continue to employ superintendents in a state where we already have a significant shortage of superintendent candidates?
I think it's reasonable to assume that there are boards who would feel that way. Many boards, however, might feel just the opposite. I think that would have to be a function of the community and the board that represents it. I will say this. The power, and I've spoken to this many, many times, the power of local control and the ability to vote in elected members of the representative communities is a powerful one. It's not one that we want to throw away. It's not one that we want to ignore. The job of a superintendent is not, you'll hear me say it, it is absolutely not to determine what the issues of the community are under the law in terms of how and why politically we perceive them. We act on the board. When the board drives us, we advise them, we support them, we follow the laws that we can, but we work with our council, we work with our board to enact what it is that we're charged to do, to make sure that we administer the policies of the school district. And that's all Marcy did. She worked within the boundaries of her role.
Follow up, you can do it quickly.
Thank you so much for allowing me a follow-up. And if, as we're in your role as an assistant superintendent, if you believed your school board directed you to do something that you believed was illegal, would you have recourse?
Absolutely. We would, any superintendent who had question about what they were doing was illegal under the law would, first of all, they would represent through legal counsel, whatever that perspective is. They would bring legal counsel to bear on the board. The board would hear those conversations in non-public setting. They would have maybe public setting. They would have those conversations, and then they would have the opportunity to direct the superintendent to take action in accordance with what they believed was the appropriate action.
Thank you so much.
Any other questions? Seeing none, I'm going to close the hearing. HCR 6. 9, whatever. 6. Okay. Okay. There's nobody's We're going to start the next hearing in 1 minute. Committee can take their seats, please.
Person on this side just went to the bathroom because she thought we were on break. I'd ask you to wait for us signing this.
I'm going to call the hearing for House Bill 208 fiscal note to order and recognize Representative Jess Edwards, sponsor.
I think it's still good morning, barely. I'm Representative Jess Edwards. I represent the towns of Auburn, Candia, Chester, and Deerfield. It's Rockingham District 31. I'm here today to introduce House Bill 208 with a fiscal note. What 208, the way 208 was born, it was before bill submission, I try to make a habit of going to a school board meeting and asking them what I could do to help them. And the school board in a public hearing asked me to support 4 bills. I negotiated it down to 3. The other one wanted a bunch of money retroactively. But this one seemed to be reasonable. They are having trouble hiring school nurses under the existing law. And the principal, Lori Collins, thought that if we could take another look at the requirements for the position, it may be possible to make it a little more flexible for hiring to take place without violating the critical need to maintain quality of care. And so, listening to her, I drafted something up, and then I talked to my good friends over in the School Nurse Association. I think you might hear from them. And I believe we've found a mutually accommodative position where we can make the law a little bit more flexible and keep it within the professional standards of our school nurses. So if you look at line 2, it basically says, it adds that in their current experience that they could have acute or chronic care experience. It changes the requirement around pediatric nursing into showing a priority within pediatric settings. It creates an and/or around the skill sets so that people of varying backgrounds might become eligible for consideration. Of course, the hiring, you'd still want to hire the best available, but if you can't hire anyone, you have no quality, you have no school nurse. And that's what at least the Auburn Village School is confronting, is they don't have one because they can't hire one. And so, so the other on line 7 is another tweak to talk about aptitude. In other words, you know, if we find a less experienced, i.e. maybe younger nurse that has great potential and a great passion for this line, that they ought to have an opportunity to compete and hopefully have a merit-based system to reward the best qualified. So that's what HB 208 does. That's why I'm introducing it. I'll take any questions.
Any questions? Representative Freeman.
Thank you, Madam Chair, and thank you, Representative, for bringing forward this bill. From what I understand, you're saying this would allow districts to have more flexibility around hiring, i.e. experience and starting pay. Is that correct?
I had a hard time hearing whether you said inexperienced or experienced.
Thank you, Representative. I wouldn't say inexperience, I'd say experience.
Yes.
So this would allow the districts to have more flexibility around experience and or starting pay. Is that correct?
I'm trying to be too precise, I think. I think what the flexibility does is it trades off some of the harder positions around stated experience to allow for aptitude and potential. So in that way, in that regard, I think it's meant to be more flexible.
Thank you.
Representative Cornell.
Thank you. Thank you for taking my question. Are they having a hard time hiring people because of these reasons, or because school nurses now have to be certified by the Department of Education and have 2 certifications, one nursing and one with the Board of Education?
I had really asked, I pleaded actually, with the principal to show up and explain the problems she's had with the hiring system. I know that in the public comments during the school board, she went into length about how she would present someone that she thought was a good applicant and had trouble at the Board of Education level getting sort of their approval. Now, I have to disclaim all of this. This is not my subject matter. She told me this in a meeting in August or something. I've had a lot of fun since then, so I don't know exactly what she said to me, but I think her comment was that the challenge was getting an applicant past the Board of Education criteria.
Thank you.
And I showed her this language, just follow up on that. I've showed her this language and she thinks this language would help.
Representative Damon?
Thank you, Madam Chair. Thank you for taking my question. It's not entirely clear to me, and perhaps you can help me better understand this, although it may be more for the nursing people. In line 2 and line 3, I don't really see the proposed new language as changing the qualifications because the original language says current experience in pediatric nursing or other related nursing areas. So how is changing it to a priority in pediatric settings? I just don't see how it changes anything.
I drafted this in August and submitted it to a few reviews. This ended up kind of in my voice probably, and I just wanted to clarify that regardless of the other related nursing areas, there was still a priority on pediatric, that we weren't dumping pediatric. We were just putting it in the context of it's being a priority, not a requirement that we keep someone from being compliant.
I appreciate the intent.
Okay.
Representative Woodcock?
Thank you. Afternoon, Representative Edwards. I appreciate the fact you're bringing something to help this. I just wanted clarity on your response to Representative Cornell. When you were talking, just said the Board of Education criteria, were you talking about the local school board or the Department of Education licensure criteria?
I think I meant to be referring to the Department of Education criteria. Yeah, the school was happy with the applicant and was not allowed to proceed with hiring, I think.
May I follow up?
Follow up.
Thank you. Just two quick other ones. I heard you refer to the School Nurses Association. Is there a person here? Okay,
Yes.
okay, I want to ask you that one. Final one? Thank you.
Short.
Thank you. How do you determine, what do you mean by acute care?
Acute care, it's a word in healthcare. Acute is kind of an emergent, injury-based sort of care. Like if acute care might be kid running down the hall and slamming their face into the door, they would have an acute care situation, something that needed to be taken care of at the moment, and that's juxtaposed against chronic, which is just like long-term. If the kid has early onset diabetes or something, that would be a chronic care situation.
I only asked that.
They're terms of art.
Yep. I only asked that because I was referring to Representative Damon's comment about it. It's similar to nursing. They're a nurse, so they have skills that deal with that. That's all. It just seems similar. I didn't know if there was a separate entity. I got it. Thank you.
Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. I'm just curious on line 9, it says providing leadership, and it did say in the profession and professional nursing practice. Why are you striking out profession?
Because it's just a cleaner sentence, and it doesn't make it sound like there are additive requirements when it's really just one requirement to be able to demonstrate leadership. So just for simplicity.
Any other questions? Seeing none, thank you very much.
Thank you.
And I'll call Sean Thomas.
Thank you, Madam Chair and members of the committee. Nice to be with you all today. My name is Sean Thomas. I'm with Demers, Praysall, and Thomas here in Concord, and we have the privilege of representing the New Hampshire School Nurses Association. So I'm pinch hitting today. We had a wonderful school nurse lined up to testify, but unfortunately she couldn't make it at the last minute. So this will be brief, and I'll do my best to answer any questions, but really just want you to know that we had talked to Representative Edwards very early on during the LSR process. This bill, these are his ideas, obviously based on conversations he had with the Auburn Village School and his ideas, but we very much support it as an improvement to what is a very important certification, and we support it because it recognizes, I think, the current nursing shortage and the need for more flexibility. So that's how we view it. We support it. We think it's a good thing. And to the extent there are any questions, I'll do my best to try to answer them.
Any questions, Mr. Thomas? Representative Damon, then Mr. Woodcock.
Thank you, Madam Chair. Thank you for taking my question. Nice to see you.
You as well.
Are you aware from the Nurses Association of other additional approaches that they might like to address this shortage of adequate school nursing?
Yes, I mean, that's an interesting question. So this is an issue I'm sure many of you are familiar with. We've seen it now over the last several years. I think there's been tweaks, if not every year, maybe every second year. And I think that's just the reality of the sort of the nursing shortage and things that have transpired since COVID, especially. But I think it's important, the history is important with respect to the certification program. It's relatively new. I mean, so it starts back in 2016. It was actually a collaboration with the Department of Education at that time in response to complaints and concerns regarding the quality of school nurses. So that's sort of the impetus. That's why we have the certification program now, and I think it serves an important function. Like Representative Edwards said, there is a critical need for high quality health care, and that's really what this establishes. I mean, if you think about school nurses, in a sense, it really is a specialty. They may be, in most cases here in New Hampshire, the one medical professional in the building. They need to respond to a number of issues, make quick, informed decisions, particularly emergency situations. And these are things where really maintaining that high standard is important. And that's really why we think the certification program is important. And so to the extent there are little things we can do to improve, to expand flexibility or increase flexibility while still maintaining that standard, we think that's a good thing. And that's why we support this bill. And I think, but in terms of specific ideas beyond this, I haven't heard any, unfortunately, but I mean, we're always open to ideas.
Thank you.
Representative Woodcock.
Thank you, Madam Chair. Thank you so much for taking my question. I just want to be clear on what you just said to Representative Damon.
Yeah.
So is your position or the position of the Nurses Association is that they are supporting the DOE certification requirement?
That's correct. Yes, very much so.
Okay, thank you. Thank you, Madam Chair.
Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. So I'm still struggling a little bit with the language on lines 2 and 3 because it doesn't appear to really change it that significantly. Can you speak to how that actually changes it?
Yeah, so I think the concern among some who apply for these positions is they may have significant experience in acute or chronic care settings, not necessarily in pediatric settings, and they are kept out of applying or becoming school nurses. And so the idea here is rather than focus specifically on experience in pediatric settings, you would allow hiring folks who have more acute and chronic care experience, and that translates equally well into the school setting as well, because at the school you're dealing with those types of issues.
Follow up.
So primarily you're saying that the wording and having acute and chronic care first will help them in advertising the positions to attract more candidates?
I think it expands the pool of available applicants. So you, rather than saying you're only eligible to apply to the extent you have pediatric experience, this would, if to the extent you didn't have pediatric experience specifically but had acute chronic care experience, you could also apply where maybe now you wouldn't, or you wouldn't be able to be hired.
Representative Hall.
Thank you, Madam Chair. Thank you for taking my question. So the word priority, I'm thinking it actually says they have to have experience in a pediatric setting because it's a priority. How is priority measured? Is that just like more than anything else? Is that over 50% of their time? You know what I mean? It looks to me like they have to have the pediatric experience.
Yeah, I mean, that may be a better question for Representative Edwards, but I guess when we looked at this and when I read this, I think it's sort of referencing an ideal situation where still there is some pediatric experience, but I think the change here is that acute or chronic care experience is really what is important. Pediatric would be a nice plus, but wouldn't be necessary. I think that's sort of how we read that change.
Can I have a second question?
Follow up. Go ahead.
Okay, follow-up, second question. The licensure versus certification. Am I correct that certification with the DOE is every 3 years? Licensure is every 2 years, is that right? Or did I read that wrong? somewhere?
Licensure is every 2 years, and I believe, yes, certification is every 3 years.
Thank you.
Representative Cornell.
So do you think it's gotten more difficult for districts to hire school nurses now that they have to be certified by the Department of Education and hold a license in nursing? They have to have 2 licenses, which is more difficult to get. I know that in Manchester, there's a shortage of school nurses. And I think they're having a hard time finding them because of the certification and licensure.
Yeah, I mean, that's a fair question. And I will say, I think given the current circumstances, the nursing shortage issues, I think that's contributing to some of these issues. I don't think it's the certification specifically. Again, this goes back to 2016. There hasn't been a problem except in the last probably several years. And my understanding is there's relatively few openings in school nursing outside of the 2 big cities, Manchester and Nashua. And even in those cases, I believe they're using agency nurses. I think that's really the issue in Manchester and Nashua. That's my understanding anyways.
Follow up.
They aren't allowed to use agency nurses aren't allowed to leave the agency to be hired by the school district, so that's causing a big problem too. But I don't think it's just in Manchester and Nashua. I think it's statewide.
So from what I've been told, it's a handful or less than a handful outside of Manchester and Nashua.
Representative Selig.
Thank you so much, and thank you for taking my question. And if you don't know the answer to this and want to respond later, that's okay. Would this allow someone who, let's say, graduated from nursing school in December, but did I don't know if they do internships in nursing programs the way they do in rotations, thank you, the way they do in education programs, would that person then be, based on this bill, eligible to be hired this week as a school nurse?
That's a good question. I actually don't know specifically. DOE may know the answer to that question if they intend to testify. I'm not sure. But this particular bill, I don't think changes the answer to that question. Again, it's changing sort of the experience requirement. I don't know that it changes with respect to new grad and how all that intermingles. I don't think there's a change there. But again, I don't know for sure. I'm sorry.
Thank you.
We do have the opportunity to have Steve Appleby come up and answer technical questions. Do you have a question for this gentleman? Okay, Representative Damon.
Thank you. So I think I'm understanding from the discussion that line 2-3 in the proposed language is saying that a person who has 3 years of experience in either acute or chronic care, not necessarily any pediatric care, could be hired for a school nurse position. However, if there were other candidates who had pediatric care experience, they would be given priority. Is that basically what it's saying? Representative Edwards is nodding his head to me.
Then that must be what it's saying. No, I agree. I mean, I think that would be a decision the administrator could make, but I think this particular language affords them that flexibility.
Yeah. Any other questions? Seeing none, thank you very much. Do we want to call Steve Appleby up?
Thank you.
For any technical questions? Okay, come on up. All right.
Good afternoon, Chair.
Hi.
Representatives. Stephen Appleby, Auburn, New Hampshire. Department of Education, Educator Support, and Higher Education. So I heard lots of questions. Fire away.
Questions for Mr. Appleby? Representative Cornell? We'll kind of go this way. All right.
Thank you for coming, Steve. Our nurses finding it difficult to get the certificate from the Department of Education, to go along with a licensed nurse?
Yes, thank you for the question. I would say, based on the current statutory language, it is restrictive. And very often I have conversations with superintendents around the restriction that the statutory language states. So, for example, the proposed statutory language removes pediatric nursing or other related nursing areas. That wording, what that means is we see applicants at times who've worked, for example, in a retirement home. We can't say that's related. We just can't get there. If they're working in a retirement home as a nurse and they apply for a license because now they want to work in a school, the current statutory language says related area. We don't interpret working in a retirement home as a related area. So I would say the current statutory language is restrictive.
Okay. Representative Balboni?
Thank you for taking my question. Last year, if I recall, we made some changes into those certification requirements. Has that helped at all?
Thank you for the question. I would say on balance, no, it hasn't made any difference.
Okay. Representative Selig?
Thank you. I'm sure you heard my question about the newly graduated nurses. I just wondered
Yes,
how
thank
that
you.
relates, please.
Yeah, thank you. The requirement is that they had 3 years of experience.
So may I follow up? Sorry. If that is as a student rotation, would that be considered sufficient experience?
So I would have to check with our legal counsel, but on the face of it, that would sound like that was experience gained before they held their registered nursing license. And typically, we don't count experience in a role. In fact, we have an administrative rule to this effect, that if you're in a role that requires a license and you don't possess that license, we don't count that experience towards that license. Now, in this instance, whether or not that would apply, I'd have to seek advice.
Representative Freeman?
Thank you, Madam Chair, and thank you, Mr. Appleby, for coming in front of us. I'm sure we're going to have a wonderful relationship in this legislative term. I do have a question for you about some of the changes that I saw when I was in the legislature 6 years ago. And one of them was about the educational requirements of school nurses. It was associate's degree, but then associate degree nurses were grandfathered in as of 2022, that as long as they had an associate degree and were enrolled in a Bachelor of Science degree in nursing, they could be and completed that program within 6 years, then they could be a school nurse. Are you finding that that particular administrative rule is prohibitive for districts for hiring nurses? Have you seen
Thank you for the question. I would say on balance, no. I think that's actually less restrictive, having that language.
So you haven't seen any pushback? I'm sorry, follow up. I apologize, Madam Chair. I have my hand up all the time and you don't see me, so I'm just. So you don't see any pushback from that particular administrative rule change?
The only pushback that I've witnessed with regard to that change are individuals who can't complete the requirement in the added time.
Okay.
So they have an associate's, they get to the end of that time period, 3 or 6 years, and then they can't move forward because they didn't get that bachelor's degree.
Very good. Thank you so much.
Representative Hall?
Thank you, Madam Chair, and thank you for taking my question. So the example you gave about the nursing home, so the nurse comes in and wants certification, but if she or he have been in a nursing home, then the language here says with a priority within pediatric settings. This language wouldn't change that at all, right? Because they haven't been in a pediatric setting? Is that right?
Yeah, thank you for the question. Well, it says a priority within, it doesn't say experience in. Right, so I would again seek legal advice, but my just back of the envelope look at it would be this is less restrictive than the current statutory language.
Follow up with just the word priority. How do you see the word priority in this language? I mean, you have to have done it.
I'm not, thank you for the question.
I know you didn't write the
I'm not an
bill.
attorney, but we would look at that and say, okay, well, if they have it, great. Priority, it doesn't say they have to have it. We view that as less than a must or shall. Again, I could be wrong. I'm not an attorney.
Any other question? Representative Woodcock?
Thank you. Thank you once again for being here and helping the committee. I'd like to go back to your comment that you just made to Representative Hall, the priority piece. So if they don't have it, they do have it. I was trying to figure out if it's the local priority in hiring or you as a certification, but I was getting a different gist when I heard you speak. Basically, you're saying that verbiage and priority doesn't mean anything because it's just not necessarily reason, doesn't matter. You either have it, you don't, it doesn't matter, it's just a priority for someone. Is that fair?
Thank you. I think in regards to licensure for school nurses through the Department of Education and the State Board of Education, the word priority is not shall.
Right. So it doesn't have an
Again,
impact.
I would seek legal counsel on our end, but.
Okay. Thank you so much. Thank you, Madam Chair.
Any other questions? Seeing none, thank you very much. And I'm going to close the hearing on HB 208 event. We're going to regroup on, what time? 1:15? 1 o'clock?
Yep.
We're gonna regroup at 1 o'clock.
Welcome back, everybody. We're ready for our one hearing this afternoon, which is House Bill 68, making best interest placements within the same school district mandatory in the absence of a valid reason to deny the placement. And the prime sponsor, Representative Leon, is here, along with some other people she knows.
Thank you, Mr. Chairman. For the record, I am Erica Leon, representing the town of Derry, which is Rockingham 13. I'm a third-term rep, and I got to spend my first year with many people here on education. My bill is actually quite simple. It says that if a parent believes that their student would do better in a different school in the same district, the answer is yes, unless there's a really good reason to say no. I think one good reason to say no is if there's not enough space in the classroom. And quite frankly, if them moving in would mean that there's not one open seat for a kid who moves into that school's territory during the school year. That would be a valid reason to say no. Right now, we do have best interest placement, which allows a parent to ask the superintendent to move their student to a different school within the district or to one of the other options within their school district. In Derry, we don't do any tuitioning or any out-of-district placements for standard students unless it has to do with special education. So that's not relevant to my district. However, best interest placement itself does impact that in other areas. But this bill doesn't touch that. It only talks about the in-district changes. So we had a situation in Derry. We had 5 elementary schools. We now have 4. And the students from Derry Village School were moved around to different schools within the town. The 4th graders that were being moved were in their last year of elementary. These were the kids who came in with virtual kindergarten. They were massed through 1st grade and half of 2nd grade. In 3rd grade, they found out that their beloved school, that perhaps their parents had attended as well, was closing, and then they moved to another school. If there's not a good time and a good reason to say yes to most of the parents who are asking to move their child to a different school, I don't know what it would be. You had students who wanted to follow a math specialist, that they had finally come out of their shell and were finally doing a good job. They had been both been assigned to the same school, but then with the redistricting, they were moved to different schools. When you have a student who's shy and has a hard time in school, but has finally just started to flourish, I think it would be a simple move to say that they can follow that teacher who they have a really good relationship with. That request was made, and it was denied. There were other requests as well. I actually brought this up at tryouts for Little League. There's a whole broad cross-section of parents, and I was shocked at the number of parents who had asked to have their child moved, and they were rejected by the superintendent without any explanation or reason, because that's what the current law says. It expects a lot of compassion on the part of the superintendents, and I get that they have a hard job. I get that there's a lot for them to do, but accommodating our students should be pretty simple. And that is why I filed this bill. The other issue, too, is that right now when the superintendent doesn't follow the law about what to do for best interest placement, it just drags on and on and on. The 10-day requirement to have a hearing did not happen for many of these students, but there were no repercussions. This law would also say that if the superintendent doesn't respond and doesn't follow the law, then the request is granted. I think that's the least that we can do, and it doesn't go to penalties or punishments for the superintendent. It just makes that mostly yes a definite yes. So this has no financial impact because these are schools within the same district that should, under RSA 189.1, should be providing the same level of education, same opportunity for education at all schools within the district. I don't expect that this will be because one school is good or one school is bad. I expect that a lot of this will be about learning styles or getting away from a bully. There's many reasons why a student may do better at a different school. Right now, their main option is to either apply to a charter school or leave the public school system. This gives them a yes to move to a different school in district, staying in with their district, staying with kids in their community, and getting to know more that they'll see in middle school and high school. I think that this is the smallest possible step to give more options to our parents and students, and I hope that you will support it.
Thank you very much, Representative. Questions for the representative? Representative Damon.
Excuse me. Thank you, Mr. Chair. Thank you for taking my question. Does this change student access to approved private schools in district?
No, thank you for the question. This does not impact this. This is only for in-district schools, the in-district public schools. And if there's something that we could do to tighten it and make it clear that it is only for the public schools and not a private school, that was my intention when I asked for this language for OLS.
Oh,
yes.
On line 5 and line 7, it says approved private school. So that's clearly not only public schools, I think. That's a question.
Oh, thank you. I think you've had the same experience of OLS not drafting things exactly how you intended. I apologize that I have put a number of bills in, and you're correct. So we should strike that approved private school, and it should only be made to another public school or public academy. I apologize for that oversight, and I thank you for catching that.
Further questions? Representative Selig.
Thank you, and thank you for taking my question. So clearly in Derry, you have, as you said, now 4 elementary schools, and I don't know how many middle schools and high schools in your district. Outside of so we have Derry, we've got Dover, some of the cities in the state. Many of our small towns, my understanding is, only have 1 school in their district. So what would the impact be on a district that has literally 1 elementary school and maybe not even middle or high school within their community that they tuition to?
Well, thank you. There would be absolutely no impact on them because you can't move to another in-district school if there was only 1 in-district school. And in Derry, it would only apply to elementary school because along with closing one of our 5 elementary schools, we also took our 2 middle schools and turned them into a 5-6 and then a 7-8. So this is why compassion for these 4th graders really, really was needed, because I told you about coming up to 4th grade. Now they move into a 5-6 school, then they move into a 7-8 school, and then they move into Pinkerton, which is a wonderful school, but is almost like a college campus. So there's a lot of value and consistency in education. And I recognize that moving from one school to another isn't consistency, but there's also value in moving away from bullies.
Thank you. Representative Litchfield.
Thank you. And thank you. Just curious, in this particular situation where you're mentioning it sounds like there's an abundance of 4th graders that may be unhappy, how would that be navigated? Are you thinking a lottery system?
Thank you for the question. I would leave that up to the districts, but I think the most fair would be just to process them on a first in, first out, or to have a lottery system, either to pick one of the two. Because if you had a whole pile in front of you and you could choose which kids to accommodate, that would introduce a lot of problems and a lot of questions. So I would prefer to allow the districts to either have a first in, first out, or a lottery process where they would set a date, because that's what would be fair and equitable.
Representative Woodcock.
Thank you, Chairman Cordelli. Good to see you back. Good afternoon. I want to follow up. I want to follow up on Representative Damon's question, Representative Leon. The part on line 7 was talking about the private academy, private school. So you're going to request there's a couple of questions, if I may, Mr. Chair. You're going to request a change to that to take that out?
Sorry.
On line 7, where it says public school, private academy, or private school within the district. And you said that was not your intent in the bill, because obviously if they're in the school district, I understand that part. So are you going to file an amendment to take that out?
Yes, I will file an amendment to take out approved private school. The public academy is like Pinkerton or Co-Brown. And with that, in my town, the only school we send to is Pinkerton. But I know there are some schools where they have a number of different options. And Pinkerton is essentially a public school, even though legally it is a public academy.
Right.
So I don't think it would be equitable to students in other sending towns that have multiple options to exclude them from attending Pinkerton. So I will remove the approved private school, but I think it's prudent to leave the public academy.
Okay. One follow-up? Thank you, Mr. Chair. So just to follow up to that, then, going back to your initial rationale for the bill, that some youngsters are legitimately stuck in the school building that they shouldn't be, and then, except for the seat capacity, I think you said, they should have an option to go somewhere else within the school district. I'm not suggesting that's bad. My question is, why would we want to have a RSA that tells the superintendent and the local school board how to manage their school?
Well, thank you for the question. We've already given them the flexibility, and this is not just a dairy problem. I have heard from people around the state that their best interest placements are rejected without a reason. This is about accommodating students, and as I'm sure you're aware, there is a mental health crisis, and we are seeing too many kids dealing with bullying that take a permanent solution to bullying. That's one of the areas where a lot of times I've heard that a lot of superintendents say, stay there, figure it out. You need to figure out how to work with your bully. That doesn't always work. And providing this option for students to change schools to get away from a bully or even get away from a bad friend group. Because as you know, sometimes you may have made certain life choices and then want to change what you're doing. And I'm not sure if every superintendent will understand that a child has started to run with a bad crowd. They've decided that they want a new crowd. And the best way to do that is to move schools. That is a very, very valid reason to move schools because that's the student's whole future. A lot is determined by the people that you spend time with. And there's still an opportunity for a valid reason to say no. I just think that for default answer should be yes.
Okay, thank you. Thank you, Mr. Chair.
Representative Freeman?
Thank you, Mr. Chair, and thank you, Representative, for bringing this bill forward. Just a quick side note before my question is, 4 years on the Manchester School Board, I can't even begin to tell you how many times parents have requested that their children be moved, even under the manifest hardship, and they were refused with no explanation. So this bill basically says that this is to address the lack of the transparency around the rejection by the superintendent. Is that correct?
That is a large part of it, yes.
Thank you.
Representative Litchfield?
Thank you. And thank you. May I ask 2 questions?
Start with one.
One? Okay. Well, it prompted that, my fault. Okay, so my first question is, I understand the part about the transparency, but it is also stating that they absolutely must adhere to this, correct? Unless there's a spatial issue.
So it says in number 2 that if the existing language is if the superintendent does not find that it's in the best interest of the student to change the student's school or assignment, the parent or guardian may request a hearing for a manifest educational. And within that, it says within 10 days following such decision, the superintendent shall provide a written report to the parent or guardian, providing the reasons why the request cannot be accommodated. So with that, the superintendent would need to say why they're saying no to the request for the best placement change. By knowing the reason for rejection, that creates a better process for the manifest educational hardship and for the school board to actually know what is going on. There may be some very, very valid reason why a student can't be accommodated at a different school. But instead of saying, my answer is no, and I'm not going to tell you why, it requires the superintendent to make that information public. And given that the superintendents are in charge of running the school district, and the school board is in charge of hiring that sole employee, the superintendent, there should be that transparency to say why the superintendent isn't accommodating these changes.
Did you have another question?
I did, thank you. Just regarding transportation, how would that work?
Thank you. In the best interest placement law, it already says that the parent is responsible for the transportation, and this would not change that.
Perfect, thank you.
Yes, Representative.
Thank you, Chair. Representative, have you ever heard of a study by Shaquille, Anderson, and Wolf in 2016, which shows that there are better student outcomes when you provide them with student choice? And does that sound sort of consistent with what you have already studied about school choice and better outcomes for students? Thank you.
Thank you. I'm not sure if I've read that particular study, but yes, when you have the agency and the buy-in to your education and you're an active part of choosing that path, students are more involved, which leads to better outcomes. Quite frankly, we do already have some school choice options within the state, and this enhances the in-district choice, which I think is really, really critical, because if a student can stay in the district district but still meet their needs, then that doesn't really change much except that individual's experience. And I think that it's both economically sound and the right thing to do in order to support these learners.
Yes, Representative Terry.
Thank you. I've heard you reference Derry and allude to other districts where there are multiple choices that would be available, as are not the case in many smaller communities. Do you have any sense how many families and students might potentially benefit from this change that you're recommending?
Thank you for the question. I don't know the numbers because a lot of people are even afraid to speak out that they had asked for these accommodations. I put this out on one of the more vocal community groups in my town, and some of the responses from people on the school board and others within sort of one particular mindset within the town were very unkind to parents who would think to move their child from their assigned school because there's other students who might not be able to move. And because some other student might not be able to move and have that choice, they said that nobody should have the choice, the opportunity to move. I found that very, very distressing. It's almost like saying that because there's people who can't walk, I shouldn't be able to walk. It's quite an offensive statement to say that you need to be locked into a particular school based on your address. But because of that mindset and the people that were piling on, there's a lot of people who are afraid to speak publicly about their desire to move schools, especially because it's seen as anti-school or anti-teacher in order to speak out about the challenges in their town. So I've heard from people privately, but I have not heard as much publicly because people are afraid of that peer pressure.
Thank you, and thank you for identifying the differences of opinion that occur amongst parents in these schools. But potentially, what we're looking at is that it would seem is a significant number of families and students who might take advantage of this, because if I'm getting this right, correct me if I'm wrong, we're looking at all the districts that have multiple elementary schools, multiple middle schools, multiple high schools, where this could occur. So that's a substantial number that could take advantage of this if the bill were to be passed, correct?
Based on space in the other schools, yes.
Yes.
And I think that that would be an important signal, because if a school has that many families unhappy with what's been offered, then that school needs more attention from the school board and the superintendent to make sure that they're meeting the needs of those families. Because if we have a school that everybody wants to flee, we have a really big problem, especially for those students who can't move that school. And if those students that want to move become those canaries in a coal mine and let people know that people want out of, I'll use my school, which was an amazing elementary. If everybody wants out of Westlake Elementary because they're having problems, then that tells you that it needs to be fixed for everybody. I'm hopeful that that won't happen, but I'm even more concerned that we won't have those signals and kids will continue to stay in an educational environment that lots and lots of people want to leave just because we don't have that information.
Representative Damon?
Thank you, Mr. Chair. You mentioned at the beginning of your remarks, and thank you for taking my question, that lack of space capacity in a school could be a reason that the request was declined. Are there other legitimate reasons that you've entertained where a request would be declined?
Thank you for the question. I can't think of them, but I don't really want to tie their hands. There may be some reason why it can't be met, and that's why the superintendent would need to share that with the parent and the school board, because if a reason was given and others didn't agree that it was valid, then there would be a process to appeal and overturn that. But I don't want to tie the hands of the schools. I'm not looking to mandate exactly what they do, except for the fact that they are to listen to the parents first on moving their child. I think that that is a pretty low bar of requirement, especially because because families are able to leave the schools already. I want them to stay in district. Because I'm an all of the above school choice person. I want really strong public schools and I want a whole variety of options. And I think this will help us have better, stronger public schools.
Seeing no further questions, thank you very much, Representative.
Thank you.
And we move from of Representative to Dr. Leon. Welcome to the Education Policy Committee.
Good afternoon, Chairman, members of the committee. Thank you for having me. My wife's a tough act to follow. We both have strongly valued education, which is where I think this bill is coming from. If I can, very briefly, I think it's worth mentioning, we have such a rich history in our state with respect to education. Three people who I think everyone in this room knows. I'm going to go back to a book from 1848 called The Lives of the Signers of the Declaration of Independence. Josiah Bartlett was an immigrant from Massachusetts. It was a separate state, a foreign state. Actually lived. Yes, it still is. I'm from California. It's just as bad.
Did the recording system get that?
So what a lot of people may not know, there's a Josiah Bartlett Center here now, but he was a troubled child. He had problems with education. What worked for him? It was actually a hybrid education where he drove his own education at home. After that, family friends, someone with the last name of Wentworth, who I think a lot of people have heard. I went to grad school at Dartmouth. Pretty big name in the state, actually mentored him. He didn't do so bad. At 16, he entered the field of medicine, which was not an untypical age at the time. That's what worked for him. William Whipple grew up a little poorer. He was native, actually born in Kittery, New Hampshire, which is now Kittery, Maine. He went to a public school, which at the time was called a common school, a school for commoners. He absolutely excelled there, not only through hard work, but through the mentorship of his parents. After school, he wound up going out in the ocean. He was a seafarer. He and his brother had learned enough. They became entrepreneurs and were very successful after that. The rest is history there. I'm focusing, there's much known about them. I'm trying to just stick to their educational choices. Matthew Thornton was actually an immigrant from Ireland, a little further away, across the pond, as some of my colleagues in Ireland would say. I don't drink whiskey, so I'll let others argue over where the best stuff comes from. But long story short, Matthew Thornton grew up in a very, very wealthy family. When he immigrated here, he not only had no trouble getting into medical school, his family name carried him into medical school. And the same Governor Wentworth that was friendly to Josiah Bartlett actually opened doors, if you will, for Matthew Thornton. So 3 very important people in our history. 3 people who were very involved in writing the Constitution, where we get Article 84 from, Article 83. If we fast forward to today, I'm just going to share, I've taught many things. I've taught scuba diving, which is a pretty cool thing. I've taught classes there. I was sharing with my wife on the way up. One of the best classes I taught was a class of deaf students. And apparently I did really well. They listened so well above water. When we went below, there was no remedial training needed. That had never happened. It was the easiest class I've ever taught. And then I had 3 more. They were very different from some of the other special needs students I've had. I've coached Special Olympics. Let me tell you, you see a Special Olympian crossing over the finish line, you'll be in tears. It's pretty cool. They're just as excited when I see my son hit a home run. They're just as excited. It's really cool to see. That's education. I was only one person in their life. I've taught at the graduate level. I've taught at the postgraduate level. I still teach medical education and oncology. I've taught first aid, basic life support. I've taught CPR to firefighters in New Hampshire, a wide breadth. And one thing I can tell you, I've had a lot of amazing mentors. Every single teacher has a different teaching style. Everyone has a different teaching style. If you have, any of you haven't read a book called The Last Lecture, it's worth reading. Put politics aside, read this last lecture. This person was diagnosed with pancreatic cancer, which is an invariably fatal disease. He gave a talk that it's breathtaking. Or you can read the book, or both. So every teacher has a different teaching style. And I think we've all seen this in our own personal journeys. So too does every student. And not all of them match. Not all of them will match. This bill provides a second set of eyes. And if you go back to our Constitution, Article 4, the right of conscience, this preserves it for the parents. Within our district, we've seen bullying. We've seen politics enter the classroom. Some of the stuff is absolutely amazing. Who better to guide education than parents to say, you know what, Junior's having a big problem in school X. It could be the school. Maybe it's a great school, just that particular teacher or the culture at the school is not a good fit for the student. Merely switching them, it changes things. If I can, a quick example, my two boys, my younger one who's 10, Eli, you ask him his favorite subject and grab a cup of coffee because he's going to talk to you about math. Thank you. His older brother, Michael, is 12. He'll do math. He used to hate math. You put it in terms of aeronautics, he loves everything planes. I can't teach him aeronautics. I can guide him to someone who can. Giving students the choice. Our public schools, we have some great public schools now. This provides a no-cost alternative for parents and students to provide feedback within a district to say a particular school, a particular teacher is performing well to fit my students' needs. I think as Representative Leon, my wife testified earlier, if there's significant feedback about one school or one teacher, I hope we don't see that. But if that happens, maybe that's something the district needs to evaluate. This empowers parents to give the optimal outcomes for their own children. I'm happy to take questions.
Thank you very much. Any questions? Seeing none, thank you very much.
Thank you kindly.
Thank you for being here. Is there anyone else? Yes.
Holding back because the gentleman next to me had a big card too.
My mom argument.
Nope, that's fine. I just didn't want to go in front of you if you want to speak. Okay, good afternoon. My name is Deborah Howes. Good afternoon, Chairman Cordelli. It's good to be in front of the House Education Policy Committee again. My name is Deborah Howes. I am president of the American Federation of Teachers, New Hampshire. And at this time, I have to speak in opposition of this bill. If we lived in an ideal school world where all our schools gave the same opportunity for a robust public education, I would be in favor of this bill. But since that is not the case in New Hampshire, even within the same school district, I have to speak in opposition. So, as we know, every Granite State child has the opportunity for a robust public education, no matter no matter what district they live in. But while this just deals with the opportunity within the same district, because our districts do not get adequate funding for that robust public education where students have small class sizes, all the academic and behavioral support they need, and rigorous curriculum. We have districts that have to make choices. They have to do things like concentrate support services for certain kinds of academic or behavioral needs in certain schools. And if a parent comes up and says, you know, I feel it's in the best interest of my child to be in another school, and the default answer is that the superintendent has to transfer the child, you are possibly moving the student away from the support services they need, because maybe those services are located in the school the parent wants to move them out of. You are also forcing the district to say no to the parent, even though that may be, what they would really like to do is work as a team with the parent or incur expense by having the support staff travel to this school that the parent wants to transfer the child into, or hire additional staff. If you are incurring expense for the local district, isn't that an unfunded mandate? We had a little lecture about that last week. For those reasons, the automatic assumption that the district has to agree to any request from a parent that the parent says is in the best interest of the child, I have to object to this. I also don't see in here that there is anywhere where the parents and the district work together to try and solve whatever issue has come up that makes the parent believe the school is not the best fit for the child. Has there been any attempt to solve the issue within the school before transferring? I understand the example where the school is closed. There's no working around that. But in many instances, the school is still open. And is there any interim step in between? There's a lot of concerns with this bill. There's a short timeline, 10 days for the superintendent to turn it around. It seems to be asking a lot of our school districts to reply to requests and not giving them a lot of room to work collaboratively with families. And that's when students get the best results. when parents and the school community, teachers, administrators, superintendents work together, all focused on the best interest of the child. So for those reasons, I have to oppose this bill as it is written. And when we have great public schools all across the state, in every district and every school within the districts, then we can talk about having universal school choice. Thank you, and we oppose this bill.
Thank you. Yes, Representative.
Thank you, Chairman. Thank you for taking my question. In your opinion, would this bill have any effect or influence on our smaller neighborhood schools?
It would have some influence. I know where I worked, some of those smaller neighborhood schools had concentrations of support for students. So you might have parents saying, well, I want to move my child out of there to a different school in the city in Nashua because, you know, the test scores don't look so good. So maybe it's not such a good school. But then you would be moving your student away from a place that actually had smaller class sizes and a lot of academic support and into a bigger school where they didn't get as much individualized attention. If you looked at it on paper, the test scores in the smaller neighborhood schools actually, you know, might be a little bit lower on the aggregate, but your student's getting more support. So, you also have to be able to make sure a conversation is going on and that there is a good exchange of information before an absolute request that can't be denied is made.
Follow.
Also, in reference to this, I was thinking about Title I. So if I have a Title I student that moves from a Title I school, I guess that person would have to go to another Title I school, but they might be requesting a school that is not. So the services is what I was thinking.
Well, yeah, they wouldn't get, if they went to a different school that didn't have whole school Title I funding. Title I is a federal grant that provides academic support, and they would not get the same level of support if they went to a school that did not have the same percentage of students living below the poverty level. So there would be fewer adults in the school to support their reading learning, or to support their math learning.
Thank you.
Yes, Representative McDonald.
Thank you, Chairman, and thank you. The prime sponsor mentioned a constitutional provision that requires all districts to provide equal opportunities at all schools within that district. And I know that's for a fact the case in my district where we have 5 elementary schools and they all have comparable education. But you reference that may not be the case statewide. Are you aware of a district where that's not true?
I know there are districts where they have concentrations, through different grants, they have concentrated support for students with different needs, learning needs in specific buildings. So if you were to move your student away from that support, they would have a difficult time getting those learning needs met unless the district were then required to have staff travel, which incurs an expense, or hire more staff. Either way, you now putting an unfunded mandate on the district to meet those students' needs.
If I may have a follow-up question?
Yes. Yeah.
My understanding of this bill is that if the superintendent finds a valid reason, then they don't have to accommodate the request. Is that not your understanding?
Well, valid reason is not defined. So when something is very open-ended like that, you don't know what's included and what's not. So you're leaving it open to interpretation, which can be very dangerous because we may agree, but it's not written down, is it?
If I may, the prime sponsor indicated that spatial issues, for example, may be something that constitutes this. And I would agree, I would understand that what you suggested, if they are specializing, perhaps English language learner students at one school, special needs accommodations at another, I would recognize that that is also a valid reason. Would you not agree with that?
We would hope that
that would be recognized, but it also could lead to more lawsuits. Are you comfortable funding that from here?
Are you
It
asking a
depends of
question
that.
to me?
From the
Right.
state treasury? You're gonna fund all the lawsuits?
Right.
Me personally?
Yeah, we'll address the questions this way.
Okay, well,
Yes, Representative Freeman.
Thank you, Mr. Chair, and thank you for taking my question. So one of the scenarios I'd like to work up and get your opinion on is if a child is being bullied relentlessly and all the modalities have been utilized to address that bullying with the person who's allegedly doing the bullying, the child, the parents, and there's no resolution to it, and the child may be in physical danger, would you think that would be an appropriate reason to grant the request to move that child to a different school?
with the hypothetical you posed, that sounds like a classic case of manifest hardship, and I believe those have been granted. I can't speak in every instance, but that does sound like one that fits that statute.
Mr. Chair, may I have a follow-up?
You may.
Thank you so much. Would you believe that actually I do know of requests that have been refused in spite of manifest education hardship, and these were the exact scenarios? Thank you.
Yes, Representative Morse.
Hi. Thank you, Mr. Chair, and thank you for taking the question.
Sorry.
So
You're the wrong person.
just to kind of wrap it up in the subject of math, for instance, let's say, we got two geniuses sitting here in the room, right? And let's say they're in their current elementary schools don't offer the same curriculum as, let's say, the next elementary school within the same district. Maybe the other curriculum is a little bit harder and more challenging for the student. So it seems to me that this bill, for instance, would be kind of like a last choice for when all negotiations fail. So that way the parents have the ability to send their kids to the school that would best challenge their needs at that time. Am I wrong?
I don't see anything in here about all negotiations failing either. So that part would certainly need to be stated a little more clearly. And to get back to a previous question, having different curriculum in different schools in the district is not something that I have encountered. So with the exception of high schools that sometimes offer, like in Nashua, North High School might offer a class that South doesn't, but the students do indeed go back and forth. If there's a class they want to take at one and they attend the other. But they don't transfer schools. They just travel for the one class. There's a bridge between them. You can walk. But I do not know of any districts that have like a different curriculum at the elementary level in one school than in another. So, you're asking a hypothetical that I don't know there's any place that does a situation like that, a magnet school type thing. Again, you want to fund every school so they have a robust curriculum, then we could have them start specializing and have magnet schools. So you solve the first problem, we'll work on the second.
Yes, Representative Terry.
I noted that among the several objections that you cited with respect to the bill, that you mentioned, I recall, unless you correct me for having misheard, that the 10 days specified here following the decision being made was a short turnaround time. And I'm just trying to understand, if a decision is made, presumably there's a reason why the decision was made, and I'm wondering why it would take more than 10 days to communicate a decision and the reason for the decision. And if it's not enough time, why would it not be enough time, and how much more time do you think would be ideal to allow for a decision of no, and here's the reason why? Thank you.
Yeah, I'm just going to withdraw that. I was speaking, not looking at my notes off, and I was thinking it was a 10-day time to make the decision and communicate it, not to communicate once you made the decision. So I got ahead of myself in my thoughts there. So, yes. 10 days would be short to go through the whole process, but not to tell people once you have made your decision. You are correct.
Thank you very much for that. Any further questions? Seeing none, thank you very much for your testimony. I think we have one more pink card coming up.
Thank you, Mr. Chairman, members of the committee. Jerry Frew, Associate Executive Director, New Hampshire School Administrators Association. I had not planned to testify on this bill, but several questions came to mind during listening to testimony that I just would think that it's important to have as part of the discussion, determining what to do with it. The word "shall" seems to suggest there's little discretion in the decision-making process, and certainly, folks want to do what is in the best interest of kids. A valid reason suggests, I'm not quite sure what valid reason means, and I think about this from the perspective of a superintendent who was in a regional school district. We had one school board, but 7 towns. And so if someone from New London wanted to send their child to Warner because the parent worked in Warner and that was the valid reason to want to transfer a child to Simon School, would that have to be accepted, whether or not the population at Simon School, I'm going to say 4th grade, had 15 students in it when perhaps the New London school had 15, but 15 in one schoolhouse, and those of you that have been in education know well, 15 students in one classroom can present one set of issues, and 25 students in another classroom could be very easy to deal with and not present any issues at all. And so I'm wondering, does the discretion, does a valid reason be that those children, that classroom that you want in Warner is filled with a number of disciplinary issues, and frankly, your child, in the judgment of the educators, is better served in the class of 25 in New London because there are no discipline issues there, achievement's high. So what's the valid issue? Is it the parents' work need? And I'm all about collaboration. We are all about collaboration with parents and trying to make the best solutions, but it would seem that we need a little bit more direction in something like that. And that was, parents deserve explanations. I agree with the bill sponsor. Parents deserve explanations, plain and simple. 10 days, Representative, plenty of time. If this body says 10 days is 10 days, it's 10 days. We can do that. That's not an issue. So I just would ask that you contemplate a little bit more definition around what's a valid reason and compelling the shall. The shall can be problematic, and that's all I'm saying. Thank you.
Representative Balboni.
Thank you, Mr. Chair, and thank you for taking my question. I have some questions about student privacy issues. Having served on a school board in my hometown for many years, I know that whenever we had special education issues or issues with students that were requesting manifest hardship or transfers at all, there literally is a wall put between the administration and the school board members. We are not entitled to have that information. Do you see any student privacy concerns in this?
Thank you, Representative, for that question. I do see some potential student privacy issues because if the superintendent's was required to make the placement, they might know based on the knowledge that they have that that's not necessarily a great placement for an additional child. But you can't say it's not a great placement for any additional children because we have too many behavioral issues in that classroom.
Thank you. Representative Woodcock.
Good afternoon again, Ms. Crew. A couple things in the bill I just want your opinion on it. I agree with Representative Leon that this may be a reasonable solution for bullying.
100%.
And sometimes that's the only solution. But I have a concern that there's a lack of specificity when it talks about how many times during a school year a youngster can move. I'm concerned about what time in the calendar you're going to allow that movement, if it shall be, that's whether they request it. And the third one I'm really concerned about, I want your just quick synopsis of those 33. The third one, I'm concerned about all the data we have on learning that happens with youngsters who have multiple transfers to schools and the lack there. So could you do like a thumbnail on those three issues, in your opinion, from being superintendent?
Thank you for the question, Representative Woodcock. Certainly, the number of transitions in a school year and the time of those transitions play a definite role in not only the achievement and the opportunity for that student that's being transferred in, but also the kind of the dynamics, if you will, of the classroom and the rest of the students. And I would also have concern, again, I'm going to go back to the regional district, Conway being one, SAU 16, regional type things. When you take a child during the school year and move them to another town, so to speak, and change the friendship group, change the dynamics, that takes adjustment time for everybody. And I think that studies, I can't cite the studies, but I think good common sense would say that it would be a disruptive piece.
Thank you. Thank you, Mr. Chair.
Any further questions? Seeing none, thank you very much. Oh, I'm sorry. Representative Litchfield.
Thank you. And thank you for taking my question.
Sure.
So am I hearing you correctly that if we set certain parameters around this where the change would take place, let's say, whether it be the beginning of an academic year or let's say after the winter break, the Christmas break, excuse me, that would be best and that would be, and I just want to take it a step further. I'm looking at this, I see pros and cons in this, definitely. I can see both sides. But we have someone here that is saying, I support school choice, but she's trying to keep it within the public school system. Yeah. So I would think we would want to support that. That's my concern. So I'm just wondering what we could do best to serve this.
Sure. Thank you for the question, Representative Litchfield. It's going to sound like a cop-out answer, I think, probably to some around this table, but I think local decision-making is really important there. As a superintendent, we accepted a high school transfer because of a bullying incident after the first quarter of a school year with a neighboring school district. Just a handshake between two superintendents. Yeah, let's get this done. It's the best interest of the kid. The kid graduated from our high school and lived happily ever after, I guess. I don't know. But there's a certain level of, even within our district, there were policies that would allow inter-town transfers. So I guess what I'm saying is that the local decision-making process can deal with some of these things, and because they know what's best at that point in time.
Thank you very much. Seeing no further questions, thank you very much for your testimony.
Thank you.
And we'll close the hearing on HB 68. And we'll take a few minutes break while we prepare for our executive session. Right.
So you're gonna act as the vice chair and vote first?
Yeah.
Okay, hang on.
Hmm? Right. Okay. Okay. Okay, we will get started with our exec session. We have several bills to discuss. And we'll start off with HB 384, which was a bill regarding prohibiting bullying. We have two more bills, one of which came in just recently regarding bullying also. So what I'd like to do is hold this one. I'll double check the due date on it, but hold this and get the other two done, and then maybe have a work session to talk about the three bills and what we actually need to do in terms of bullying. I know some people had some concerns with some of the provisions in 384. So we can talk over the three bills and see what we actually want to do on the subject. Okay? No, don't have to. Yeah, don't have to do it. The next one is talk about HCR 6, the one we heard this morning. I think I would like to hold on this one also. I missed some of the testimony, especially in regard to court cases. I'd like to go back and listen to that as a couple of other people. And I think that there are some legal ramifications since it is in the courts, and I want to research more about what happens with a House concurrent resolution. So I'll do that research and then reschedule this exec session also. Representative Hall.
Thank you, Mr. Chair. So you're not, this is just holding it to get more research. It's not
Correct.
holding it to get a decision or anything like that.
Correct.
Okay, thank you.
So let's go back up to the top, or what I have as a top on mine anyway, which is HB 71, related to school shelters. And I'll look to Representative Nato for a motion.
Thank you, Chairman Cordelli. Yeah, I do want to motion this to pass.
Okay, do I have a second?
I'll second that.
Okay, Representative Nato, do you have a discussion?
Yes, Mr. Chair. Just a small observation of mostly safety for our most vulnerable, the children, and also the staff in regards to what may or may not be brought into the school as far as either drugs, weapons, viruses, disease, where they're not inoculated in coming into this country. We have no idea. So it would be something that we would have to really take into consideration.
Thank you. The seconder, any comment? No? Okay.
No, thank you.
Any discussion then on the bill and the motion? Representative Balboni.
Yes, I would not support not to pass at all on this bill. First of all, it's talking about emergency shelters. The schools are often used for emergency shelters and weather events. And who is responsible for checking the status of those seeking shelter? When you are in an emergency shelter situation, the children are not in school. So I don't understand the concern for children's safety in the schools at that point. And in regards to some of the other statements that have been made regarding disease. One of the provisions of this bill, if you read the fiscal note, it is going to cost the state of New Hampshire $12 to $18 million annually in loss of federal funds. It violates federal civil rights laws, as the U.S. Department of Housing and Urban Development does not require citizenship documentation for certain programs. The term specified aliens seems to include all non-citizens, including permanent residents, green card holders, and persons with refugee status. These people are all entitled to be here legally, and this bill is prohibiting them shelter in emergency situations.
Further comment? Representative Woodcock.
Thank you, Chair Cordelli. I don't know the intent of the maker of the motion, but the other concern I brought up during the hearing, and I'll bring it up again, that we have many schools that are available in the summer and open that could be used for emergency shelter. And I don't know why, when I asked the spokesperson that wasn't there, it was sort of like a no, you can't use it at all. My question is, there are every school. I mean, I'm thinking of my own community. We have 5 schools. 2 of them I know don't do it in the summer, so it's just open. So just why would we prohibit every school district from saying you can't provide emergency shelter when you have emergency facilities there? That doesn't make much sense to me. I mean, where we are, regardless of who's supposed to be in it. Thank you.
Thank you. Yes, Representative Cornell? Okay. Representative Morse?
Thank you, Mr. Chair. So this bill isn't talking about banning people with green cards and whatnot from being able to access the schools. On line 11 through 12, it specifically states specified alien means an alien as defined in Section 101A of the Immigration and Nationality Act, 8 USC Section 101A, who has not been admitted as so defined.
Yes, go ahead.
That's one part I have written thing. I have no idea what the hell that means. Can you tell me what that means?
I can.
From that immigration, USC, I'm just asking. I don't know.
Yes. So an illegal alien who came across the border without any documentation, entered into our country illegally.
So that's what specified alien means. Under
That's
that law.
that's what I'm seeing as the definition.
Representative Freeman?
Thank you, Mr. Chair. In support of this, I will tell you that on a more personal, my late husband worked 15 years for immigration and customs enforcement. And I will tell you the definition between alien, illegal, and asylum seeker. And at this point, the only people that would qualify as legal in this country are green card holders, refugees, and anyone with an up-to-date visa. The people who are not here legally, for whatever reason, are the asylum seekers who use the CBP app over the past 4 years. They have not been vetted. They have not been put through Interpol to see if they are in fact wanted criminals. They have not been petitioned by the United States government to their country of origin to see what their criminal backgrounds are. They have not been medically cleared. This bill addresses those individuals. It does not address or prevent refugee housing, legal aliens, anybody with a valid visa or a green card. We have seen instances in Massachusetts and New York, and I personally saw an instance at Logan Airport last year at the international terminal. They had it cordoned off. There was 500 asylum seekers behind a petition in the international terminal of Boston Logan Airport. Now, you tell me how safe anybody would feel in that situation. You want to put someone who's not been vetted through the United States government for whatever reason into our public schools, even if the children aren't there, you are exposing them to potential crimes, potential diseases, potential viruses. So this bill is more of a proactive instead of a reactive situation, so we aren't faced with making that decision. They had an instance in Roxbury, Massachusetts, where the mayor of Boston put all of these asylum seekers in the only community center they had in Roxbury. That is an impoverished part of Boston that is loaded with minorities. Those parents were absolutely wild. They took the only source of community away from their children in the inner city. We want to prevent that. This is what this bill does. Thank you.
Representative Selleck.
With all due respect, to quote the current governor, we are not Massachusetts, and the things that are happening in Massachusetts and the things that are happening in New Hampshire are different. This bill, in my opinion, is an offensive bill. I would never support something like this. I think we need to recognize that people who have come here, by whatever means they have come here, are generally fleeing from situations that are dire and desperate. And if we're so concerned about diseases, we should not be working on other bills that take away the ability for people to get inoculations and vaccinations. And we should be requiring anyone who walks into any public space to be fully vaccinated.
Representative Morris, did you have another comment?
Yes, this is in regards to a situation that happened to me a few months ago from an illegal alien when I was actually assaulted and attacked from someone who did not obey our laws because they didn't know what our laws were. I was down in South Carolina. Yeah, I know it's not New Hampshire, but I was helping with storm restoration from the hurricane we had. And there was an illegal who was drunk driving, got into a hit and run accident, and then took off. I was on the train tracks trying to help an 18-wheeler get through before a train was coming, so I was kind of preoccupied. It was a long story. The guy in the vehicle came back, and I took his keys out of his ignition because he was definitely drunk. He couldn't speak English. We were trying to get a translator app open, and he proceeded to assault me, and I had to defend myself against him. These are the type of people that are coming into the country. They don't have a law book that they go by. They're not raised here. They don't know what's legal and what's not, therefore they don't abide by it. So if we allow these people into our schools, community centers, or whatever else, we're subjecting our society to really anything. I mean, they could be putting cameras in the girls' bathrooms. We don't know what the capabilities are, but the options are endless. So yeah, as to the point, preventative. Let's make sure that we can keep our communities safe as our top priority.
Representative Damon.
Thank you, Mr. Chair. With respect to the different scenarios that are being reported in other parts of the U.S., and particularly Representative Morris, the unfortunate South Carolina experience, none of these are things that Americans don't also do. So the idea that we are blaming immigrants for drunk driving and assault as if they are somehow different is extremely unacceptable.
Representative Balboni.
Yes, I'm going back to the term specified aliens. According to the New Hampshire Health and Human Services Office, that term is not defined. And they use the closest match and when they were describing the financial impact of the bill, which is the word alien, which refers to any person who is not a U.S. citizen or national. And because of that, it can be assumed that it would include all non-citizens. This bill doesn't specify that it doesn't include people with green cards, permanent residents, or refugees.
Thank you. Representative Harvey Bolio.
Thank you, Mr. Chair. The bill is, yes, that is true. That is not specified in that way. But the refugees have a refugee program. That is some of the documentation I gave you, the Office of Refugee and Resettlement. That's where the refugees go for housing, and they have programs in pretty much every state, is my understanding. The genesis of the bill is to keep the schools for the students and to protect that vulnerable population of the students, where we've seen a lot of encroachments We've lived through COVID when they closed the schools, and we don't want to close the schools again. And I don't see that that is mean or inappropriate in any way. So, thank you.
Representative Cornell?
For, other than the fact that this is a mean bill, the Health and Human Services did say that because of the different things that we would be acting against, that government funding could be withheld and it could be 12 to 18 million per year. And they also said that according to rules, you can no longer say indeterminable. That cannot be used as an excuse anymore, no matter what former Commissioner Stevens said, who's been out for about 20 years. So we could lose 12 to 18 million dollars a year in a year when our budget is not in good shape. And my second point would be that it prohibits the use of public schools. It doesn't say public charter schools, which you know has to be included because of the statute. If you don't mention them, they aren't counted. So our public charter schools could be used if the worst case scenario happened and we had to house somebody. So they would all go to charter schools. Thank you.
Sure. Representative Terry?
Yeah, with respect to the fiscal note and the loss of federal funds, I would like to point to the current reality that we actually are now beginning to see more people leaving the country than coming into the country. So I'm not quite sure upon what premise this fiscal note was developed, but the situation has changed markedly since January 20th. Thank you.
I would just note, there was an article in NHPR, see the date, January 23rd of this year, about flights of refugees headed to New Hampshire were canceled after the president's executive order. We will not know what will happen in the future. There could be legal action related to that executive order. So I will support the motion. Any further discussion? Representative Balboni?
Yes, thank you. What you're saying is something that's in the future. What the Health and Human Services have said to us is that's the funding that they are currently receiving. It's unclear. I mean, I think you're making an assumption that the refugees that we currently have are somehow not going to be here anymore because this money is going towards them. And with regards to another comment that was made about the housing being available for refugees, sure, they have as part of the program housing, but the same as you and I, if there is an emergency in our houses and we have to seek shelter, why wouldn't they be in the same boat as the rest of us? Thank you.
Mr. Chair.
Representative Freeman?
Thank you, Mr. Chair. And this will be my last comment. I pulled this right up out of USCIS law. So any alien who enters or attempts to enter the United States at any time or place other than as designated by immigration officers, or 2, eludes examination or inspection by immigration officers, or 3, attempts to enter or obtains entry to the United States by willfully false or misleading representation or the willful concealment of a material fact, shall for the first commission of any such offense be fined under Title 18. That is the definition of an alien. A refugee is not a definition of an alien. A legal alien is not definition of an alien. And somebody with a green card or a visa that's in good standing is not the definition of an alien.
Okay. Thank you all. Madam Clerk, are you about ready with the paperwork for the roll call?
It's a lot of paperwork.
Yes.
Okay,
And
the motion is ought to pass.
Correct. House Bill 71. Motion is ought to pass.
Today's the 27th. Okay. All right. Chairman Cordelli,
Yes.
Representative Haribolia,
Yes.
Representative Terry,
Yes.
Representative Dry, yes. Representative Freeman,
Yes.
Representative Litchfield,
Yes.
Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Morse,
Yes.
Representative Nato,
Yes.
Representative Cornell,
No.
Representative Woodcock,
No.
Representative Hall,
No.
Representative Balboni,
No.
Representative Selig,
No.
Representative Kluger,
No.
and Representative Damon.
No.
10 yay, 7 nay, 1 not voting.
Right. Because of absence. Correct. Okay. Great. Thank you. Will there be a minority report?
Yes, they will. We'll be writing it.
Okay.
When will those
And-
be due? Sorry.
What's today? Monday?
Yes.
How about the end of the week?
We won't need them for
Um,
the 6th.
is next week the 6th? Yes, it is. Yes, it is. Okay. So how about Wednesday morning?
It's only Monday, right?
And yes.
It's only
um,
Monday.
Right. And the motion for the minority is ITL?
All right, let me get a paper clip on this.
Thank you very much. And the next bill is HB 129. And do I have a motion, Representative Dry?
Yes, I would like to make a motion ought to pass.
Thank you. Is there a second?
I second that.
Representative McDonald. Would the maker like to speak to her motion?
Yes, I just want to say that I have heard the term evidence-based a lot in the last 2 years. I like the fact that it's being addressed, and that's why I'm supporting this.
Representative, any comment?
Yeah, to say it briefly, I like this bill because it incorporates a scientific method into the education system with the concept of falsifiability. And then just finally, it doesn't prevent anyone from using surveys or conducting surveys, just that that has to be declared as self-reported data as opposed to evidence-based by this definition.
Thank you. Further discussion? Anybody? Representative Woodcock.
Thank you, Chairman Cordelli. Just surprisingly enough, I won't be agreeing with that. My thinking is a couple things. The first is, I understand the representative's process for this, but I'm concerned that this eliminates the chance for improvement in pedagogy by new innovative attempts, because they may not have a whole record of evidence base. We would not be able to go forward, in my mind, in education over the years if we didn't continue to relook and re-improve. Nothing in technology, we didn't relook, re-improve, and gets better every day. I mean, so just to say, nope, we're going to stay right here, we are at 2025 and call it a day. And, you know, I find that not in the best interest of education or our students. And I'm not suggesting the content, the way the content is defined is one thing, but this is pedagogy. How do we teach this? That's a whole different ballpark. I think you're limiting teachers in their ability to be professional instructors. Thank you.
Thank you. Representative Selig.
Thank you very much. I agree with Representative Woodcock that my concern with this is that it blocks the ability for school districts to test out new teaching techniques that are being developed. I think back to when I was teaching, when laptops started becoming, or computers in general, we had to go to a computer lab initially. And then we got laptops that came to the classroom on carts. And that was all very new technology and very new strategies when we started incorporating those things into our teaching style and teaching students word processing as part of their editing process, and not just peer editing by handing a written copy that their friends had to decipher their handwriting, which, you know, if the student was like me with dysgraphia, their handwriting was completely illegible. And so I think about the ways and the speed with which our society is developing. In the time since we have added technology to our classrooms, things are changing faster than we can think them through. And I just feel that this type of a bill stifles the ability, if we have to only use established practices, we won't be able to develop new practices. And so for that reason, I can't support this bill.
Thank you, Representative. Representative Balboni.
Yes, I also will not be voting in favor of this. There's something that my work as a member of the professional development, or what we used to call professional learning communities in my school district, relied a lot upon what we call best practices. Best practices are what teachers are doing in the classroom, and they share those ideas. If I'm in a group of fourth grade teachers and we are teaching a unit, I rely on my peers to help analyze what I'm doing in terms of the way that I'm teaching, but also suggest things. And that's what teacher mentors do. This bill is interfering with the way that schools and professionals work with each other. So I can't support this bill.
Thank you, Representative. Any further discussion? Representative Damon.
Thank you, Mr. Chair. One more dissenting voice over here for all the reasons that have been stated, and also it is yet again downshifting costs to local communities, and we can't afford it.
Good. Thank you. Seeing no further comments, Madam Chair. That was a little earlier. Madam Clerk.
Yes. I'm ready.
This is ought to pass motion on House Bill 129 related to the term evidence-based in public education.
Chairman Cordelli,
Yes.
Representative Harvey Bolia,
Yes.
Representative Terry,
Yes.
Representative Dry, yes, Representative Freeman,
Yes.
Representative Litchfield,
Yes.
Representative McDonnell,
Yes.
Representative Tenzar,
Yes.
Representative Morse,
Yes.
Representative Nato,
Yes.
Representative Cornell,
No.
Representative Woodcock,
No.
Representative Hall,
No.
Representative Balboni,
No.
Representative Selig,
Nope.
Representative Kluger,
No.
Representative Damon.
No.
10 yeas and 7 nays, and 1 not voting.
And an ITL motion for the minority. Representative Selig. Great. Thank you very much. I think that finishes our business for today. And you can have the day off tomorrow, but we'll be back at it with a full day starting at 9:30, I believe, on Wednesday. What time do they start?
Do you have chocolate?
Okay, just for the record, education funding tomorrow's meeting. And I think we have just hearings scheduled for Wednesday, but a full day. Thank you, everybody. Huh?
You scheduled vote for 4 o'clock?
I don't think we'll be that late.